what do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God! No!
Hi, everybody. How we all doing? Oh, shoot. All right. Well, hopefully that did it. Hey, boom. There we go. Holy crap, that was weird. Well, as I was saying before, I was so rudely interrupted by life. Good morning, good afternoon, good evening. Hi, everybody. How are you doing? That was a great way to start, wasn't it? Yeah, I'm totally unprepared for this, as you can see. I was prepared, but I have no idea what that sound thing was. It was just a sound thing. For those of you that care, it seems because I have my microphone patched through my Stream Deck. And everything happens automatically, but it seems that there was some sort of configuration error in the Stream Deck protocol. So I just happened to open the Stream Deck, and there was this big announcement that there was an audio configuration problem. So, well, good thing we got that fixed. All right, we got a judge here. Hi, Judge. Okay. This is going to be a fun case, I think. Well, I mean, fun is the wrong word. It's going to be an interesting case. Cases shouldn't be fun, per se. We'll go with the audio as soon as there is courtroom audio. And for all I know, there might very well be court audio. I just don't know. Because that's the way my day is going, obviously. So here we are. We'll bring this up so I can see it better. And this is the case of Wisconsin versus Zachariah Anderson. And for those of you that were paying attention in chat, we have Natalie Wisco here, who was on the Rittenhouse defense team. She's lurking here in the chat, and I sent her a message. She said she would try to get here at some point during the lunch hour to say hi, and she's going to have a standing invitation to join as a panel member every single day of this trial because, hey, she knows the judge, she knows the defense team. And she sent me. I wonder if I can read this here. Hang on here. I just sent her a text after if I can read this piece of information she sent me. So we're waiting, I guess, for the court to start. The order of things today, they're going to have a motion hearing before the jury comes in. They were arguing yesterday about whether a particular police officer was qualified to act as a blood expert. And they argued back and forth, I guess, and the judge said he's going to make his ruling today before the opening statement. And I was just saying that Natalie, she sent me a Twitter DM that says, I'm friends with the defense team, and they refer to this case as Stephen Avery 2.0. Case is pretty much all circumstantial evidence, and there are even burn barrels at issue. Yes, that's what I was mentioning in the description and everything. It's there's burn barrels, there's cloth. But yeah, we just don't know. And this is another case, I guess, like well, I'm gonna make this a little bit smaller so you can all see my roguishly handsome face. Didn't even get to style the stash today. Okay, well, as soon as I do that, it looks like they start going into court. So great. Let's see. Let's bring that back up. All right, it's still muted in court, so we'll do this. Now, this is like the Murdoch case. This is an important case to absolutely keep an open mind about. We talked a little bit about some of the evidence that was mentioned, but already, as we also mentioned during the stream where we talked about this a couple of days ago, this is a retrial. This is a retrial because immediately following opening statements a year ago, this case was dismissed because the prosecution did not reveal certain bits of evidence or information to the defense that they should have. And they said either give us time to investigate this and examine this potential witness or declare a mistrial. And the judge declared a mistrial. So the state has already arguably been doing things they ought not be doing in the prosecution of the case. Some would say it was an innocent mistake, others not so much. But again, there is no body in this case. No body has ever been found. No murder weapon tied to the defendant has ever been found. It's it's an interesting case. And again, one that you must presume this guy is completely 100% innocent until the state proves beyond a reasonable doubt otherwise. And that's a high burden of proof. But you can change your mind as the trial goes on. I'll admit, I was with the Alec Murdaugh trial. I was convinced that he had done this before the trial started, and the prosecution, the way they presented their case, their evidence or lack thereof, convinced me that he didn't do it. I do not believe that Alec Murdaugh committed those murders now, not because of any arguments the defense made, but just because of the terrible job that I think the prosecution has done. Flux says, ha 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 ha, love you, Jeff. Always a fun time here. Yeah. Darn, the time you want to just get out of the gate really well and start things off nicely, things happen. Yeah. Did you try blowing on it? Yes, Flux. I tried just about everything in a sheer panic, as some of you witnessed. But we're up and running now. And Alan, thank you so much for the super jet. Blow harder, Jeff. Wow. Saucy. Still no cord audio. All right. Oh, and we have Unhung Hero. Hopefully this trial is more interesting than Murdaugh. Thanks for covering something different. That's why we're here. We're here for basically 3 reasons. 1, to have 100% less Murdaugh stream. 2, to get me to the elusive 35,000 subscriber mark. I need, I think 120 last time I checked. Wow, need 110 subscribers to get to 35,000. And also Aussie Overlaw'd, who's going to be taking over at some point during the lunch hour, to get him to 10,000. Those are our goals for this trial. 35 for me, 10 for him, and no Murdaugh streaming. But I already know I can't keep that one because this is because the Murdaugh trial is an important trial. When the verdict is announced, whatever is happening in this case, we will cut to the verdict to watch the verdict live, because that's something you just got to do. Well, there we go. So what are we gonna what are we gonna do as soon as the judge comes in? I mean, well, let's fix the camera there a bit, kind of back it up a little bit. All right, that looks like about a good size. All right. We've got the motion I was talking about, where the judge is going to decide whether or not to qualify this particular police officer as an expert. Apparently, he didn't have that much experience. Eva Torres, ponytail, immediately untrustworthy. Come on, lots of trustworthy people had ponytails. Steven Seagal had ponytails in all of his movies. Come on. Don't let Aussie touch it. Trial will blow up. Well, yeah, we already had this. This was third time is the charm. This was the third time is the charm thing. DB said, where do you go? Legal Vices, are we missing the morning game of Jeopardy? We're here. Oh, and the Dragon's Treasure. Dragon's Treasure is here. We'll get to Dragon's Treasure here in just a moment, because that sound you hear right there, if you can hear the sound, is my teapot boiling with some Dragon's Treasure tea. All right. So while they were doing this, let me tell you what's coming up this week. This trial. That's what's coming up this week. We're doing this trial for probably the next 2 weeks, Hayden and I. And what we've got involved in this trial is, again, as I said, 100% no Murdaugh, except for the verdict. This gives you a little bit of freshness, something new to look at. I'm excited for this. I hope everybody else is, because I think this is just fascinating. Given, remember, for 5 months of the Clean and Sober crew says, the day you get a slick show is the day I leave. I like that the substance is more important than the presentation. Hey, that was just a bad start. And again, it was kind of out of my control. Well, it was in my control, but I didn't know it was in my control. All right. Well, it looks like we've got something going on there in court. We're all caught up on the super chats. What do you got? We have 276 people here currently watching and 230 likes. Don't forget to take the like and subscribe poll. That's the hallmark of the day here. We've got you got to hit that like button. Make sure you're subscribed. YouTube is doing one of their subscriber purges again. I know I've gotten emails from a bunch of people saying they were suddenly unsubscribed. So if you've already subscribed, please just make a quick check to see you're still subscribed. Then feel free to take the poll. Today's poll, I'm here, and smash the like and subscribe buttons because 1, this is not the Murdaugh trial. 2, because it's Judge Schroeder. 3, because I love a good whodunit. And 4, because you need to get to 35,000. We'll check back in on the poll and see how the numbers look in about an hour. All right. Yeah, Aussie's sleeping right now. Aussie Overlaw'd is sleeping. When he wakes up at some point before or during lunch, he'll pop on here and we'll see his happy smiling face. We'll talk about what he missed during the morning session, and then we'll turn it over to him. And I'll go to well, tomorrow is a holiday. Well, I guess it's technically today. It's 12:14 a.m. here. Tomorrow's a holiday here in Korea, so I'm just gonna ride this out as long as I can until I just start to fall asleep. So I'll go over on Aussie's stream and join him at the appropriate time. All right, we're zooming in on the bench, the legendary Bruce Schroeder's bench. And all right, while that's going on, as I said, we're going to be streaming this trial every day until it's done. But also the 2 regular features that I do on my channel will continue as normal. On Monday, we'll continue to have Maritime Monday, where we talk about shipping accidents, shipping collisions, things like that. Some big ass disasters. And also on Thursdays, we do O.J. Simpson Day, where we look at the O.J. Simpson trial and some of the cross examinations there by some fantastic defense lawyers, F. Lee Bailey, Barry Scheck. We're going through Barry Scheck's complete dismantlement of the L.A. criminologist Dennis Fung. We're going to be doing that for quite a long time because his cross-examination went on for 8.5 days. But aside from that, we're going to be doing this trial and this trial only, except for the very, very special Friday evening stream. We'll do this Friday morning, but in Friday evening, which is Saturday morning my time, we will have my it's still too early to call it what I really call it, but it's the F It Friday stream. It's the F It Friday stream. And what we do on the F It Friday stream is we have a huge panel of guests. We just sit around, we talk about whatever comes to mind, any articles, any stories people want to tell. But as part of that, it's a huge grift stream. It's just purely for the grift, for my grift. I grift for super chats hard and long all day long to try to liberate as much money from your pockets as possible on that one day, so I don't really have to bother with it for the rest of the month. Everything after that is sort of icing on the cake, gravy on the taters, things like that. But it's fun. A $100 super chat gets a one shot of a top tier whiskey. It looks like this month is going to be a Glenfiddich 21-year Scotch. Oof, which is, it's crushing my soul to think about, because even the worst whiskeys, you know, even the Evan Williamses of the world, the Jack Daniels of the world, the Jim Beams of the world deserve to be sipped and savored and tasted and enjoyed. And the fact that my rules make me throw down shots of a 21-year Scotch just crushes my soul. And aggregates of $100. So $10 super chats, $25 super chats, however we come up with 100, that gets a shot of a lower tier whiskey, which will probably be Maker's Mark. That's what I'll probably do for the lower tier thing. We just do it. And who do we have for guests? For those of you that know these people, you might find it interesting and amusing. So far confirmed, the confirmed guest list is Danny on Direct, Drex, Runkle of the Bailey, Meme Copium from Japan, Nicholas Starov, a newcomer to the YouTube scene. He is a labor union lawyer. He's coming on because he's challenging me to a drink off. He's going to match me shot for shot, or so he thinks. And as I was asking him, so why are you doing this? I'm the one that gets all the money. What do you get out of it? He says, I'm a Viking. So it's a Viking drink off. So he's doing this for pride and honor. So Hey, welcome aboard, Nicholas. Flux, our very own Flux, the mod in chat, the very own Fluxy Flux that's here. Steph, the alter nerd, is going to be here. Chandler Remington, who should actually be popping on the stream here in a little bit. She will be there. That'll be her first F at Friday appearance. Law and Lumber Rob, Ariadna Jacob. Ari Jacob will be here. Aussie Overlaw'd, of course. And today, LawTube Sean, potentially criminal. He's confirmed that he will be there. And Law of Self-Defense, No Tie Friday Night Branca will be there. And another newcomer, Camelot 331. I don't know if you saw his stream with Ricada today, but it was pretty darn epic. So Camelot 331 will also be here. And there's a few other people that have said maybe, and a few other people I need to ask, and a few other people I'm waiting for answers. So that's the confirmed lineup. And there's even more to come, maybe, hopefully, later. So don't want to miss that. It'll start at 8 p.m. on Friday, Eastern Time. Eva Torres, yes, Camelot. Camelot 331. T-Man, you are on the you're on the waiting list. When spaces open up, you will definitely get an invite. There's a bunch of people on the waiting list. I'm actually going to tell people that are on the waiting list about the waiting list tomorrow. And Alan, oh, see, Alan, I just said Alan, and then Alan's name popped up. I was going to say Alan just gifted 10 Legal Vices memberships. If you were one of the lucky people that got a Viking membership, they got a gifted membership from Alan, give him a cheer, give him a shout out, give him a thanks. And now Alan has said, read your screen, Jeff. I gifted 10 memberships. Yeah, I know. I was just going to mention that. Thank you so much for that. And while we're scrolling back up here, Life According to Martin says, then drink mead shots. No, mead, the blood alcohol content, the alcohol content in mead, not the blood. Maybe it's Viking. Maybe there is blood alcohol content in the mead. But yeah, the mead alcohol levels is far too low. It's just like dangerously low. All right. While we're doing this, while we're waiting for the court to decide what they're going to do and when they're going to start, I want to bring I want to bring a little mention here for something that I have to go to YouTube and take care of this. I just thought we'd hit the ground running, but I clearly fumbled, and now the court, I guess, is figuring out what they need to do. So we can just play along with the home game here. There's something that I wanted to do in relation to this, something I wanted to read to you, because I thought it was very, 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 very interesting that it happened, first of all. Where are we? All right, we will view this on YouTube. Nope, that's not what I wanted to do. Why would I want to do that? I want to do the other one. There we are. Sorry, you guys can't see what I'm doing, but I know what I'm doing. Believe it or not, I do know what I'm doing. I have to scroll down through all of the comments that I got last time, because I got two very interesting comments on the video that Aussie Overlaw'd and I did the other day. And of course, I did some minimal vetting. Lady Autumn Sky, Camelot is from Alabama. So yeah, he's from Alabama. So I'm happy Camelot's going to be here, and we may get into the fight milk. We may get into the fight milk. But yeah, so the two interesting comments I got, and I got the comments, and I said, okay, let me vet this. And so I asked a few little basic questions to get some basic vetting done. And then later this morning when I woke up, I did some other vetting, and I have no reason to believe that the person is not who they say they are. I've seen pictures and other comments and things to verify who this person is. So who is this person I'm talking about? This person I'm talking about, let's bring this up, and you can read along on the home game while we wait for Law and Crime. There we go. It's this comment. This comment went away. It's this comment right here from Zenith Anderson. Our defendant is Zachariah Anderson. Zach is my brother. I can assure you he was never jealous of Sadie's boy toys. My brother doesn't believe in monogamy. Zach and Sadie never stopped seeing each other, and they're both very aware of the fact that they didn't work as a couple, co-parented well as they could, and that they were free to be with anyone they wanted. And she goes on to give a very long, where'd it go? A very long comment from her sister-in-law. Where did this go? Ah, here it is. This is rather lengthy, but so basically, the sister of the defendant in this case has reached out to me, and I mean, we talked about potentially having her on during the stream, but I'm not comfortable with that because I wouldn't want anything that she says or anything that we say to negatively impact the case in any way. But I'm going to do some final verifications and things, and I assume it is her, but after the trial and I do a complete vet, then of course I as I said, I do believe it's her from what I've seen so far and from what we've talked about so far. But we'll do some final vetting, and after the trial, either talk about the acquittal or talk about the conviction. So I mean, that's when it kind of gets weird. I've had a few of these things happen on my Maritime Monday streams as well, where family members of the accident, have relationships with the accident I'm talking about, contact me, and it's kind of weirdly uncomfortable because I never know what they're going to say, and it's kind of hits as real when things like that happen. And so I was kind of overwhelmed, of course, highly skeptical, but it passes the smell test so far. And we're still waiting for Law and Crime here, so let's continue to wait. And while we're waiting, I thought I would read this other comment that she said was written by her sister-in-law. It says, tomorrow, Monday, begins the long overdue trial of my brother-in-law, Zachariah Anderson. Back in May of 2020, he was arrested and charged with stalking, first-degree murder, and the hiding of a corpse of Rosalio Gutierrez Jr. in Kenosha County. If you live anywhere around here, you may recall seeing or hearing about that case. I wish I didn't have to say this, but not even one of the accusations is even remotely true. Okay, well, that sounds like something that a relative of the victim would say. So, take that with a grain of salt. You might roll your eyes and think it's ridiculous that any innocent person could be charged with such heinous crimes, especially since the snippets of information in the media has decided to release all try to paint a picture of his guilt. We're asking ourselves how this could be happening over and over again for the last 3 years and still have come up with no reasonable answers. District Attorney Michael Gravely has explicitly stated that he has a personal interest in keeping Zach behind bars, and that's the only explanation we have. How can a man of justice have a personal interest in anything? The justice system is supposed to be the last place that personal feelings or opinions come into play. I wish I had the imagination to make up even half of the insanity and abuse of power that has led us here. To begin with, this is a bodiless murder trial, meaning there's no proof of a murder, no body, no murder weapon, just an apartment full of blood, a missing man, and the assumption that he must have been killed. But they have zero evidence placing Zach at the scene of the crime, nor anywhere near the scene of the crime. I'm talking none of Zach's DNA at or near the crime scene, no camera footage of him from Rosalio's neighbor's doorbell cam or gas station cams of his van passing through the area or anything. The crime scene is at least an hour away from Zach's house, so there's lots of traffic cams and other places he would have passed. They're alleging he definitely used his own van in all of this, so it should have been caught driving in that direction or something, but there's nothing, zip, nilch, nada. And it goes on for a very, very long time. So what I would suggest, if you want to read the full comments, go to the show that Aussie Overlaw'd and I did on this show 2 days ago and read the lengthy thing. Read the lengthy comment. It ends with, and if you're a crime buff or just want to support us as his family, I implore you to attend or watch the trial starting tomorrow, February 27th, 2023. It will be at Branch 3, Courtroom 209 in the Kenosha County Courthouse, and is supposed to be broadcast by Court TV, Fox News, Kenosha News, and possibly others. We want everyone to see and understand how pathetic law enforcement and our justice system has been, because it's time for Zach to get the actual justice he deserves. And maybe, just maybe, Rosalio will get the justice he deserves if a not guilty verdict forces them to reopen their crappy investigation and do their dang jobs. We can't be in attendance the entire time because of our jobs, but we'll be anxiously awaiting the verdict and with any shred of hope, looking forward to the favorable outcome. So that's what we've got. If only we had the trial to watch. So that's the trial from the defendant's side. That's what they're arguing. Rob Judge is back. Yeah, we can see how back the judge is here. The judge may be back, but law and crime certainly isn't. Yeah, there's blood in a missing person. That's kind of it. But of course, the prosecution, they have another side of this. They have another story that they're putting forward, which is that he was an extremely jealous ex-boyfriend who didn't want the relationship to end. So he went along and stalked her, put GPS tracking devices, phones and things around there, around her, followed her, and did some other things, and then somehow used some weapon with particular blunt force that the prosecutor, during the opening statements last year, when the mistrial was declared, said that there's a rug missing, and other than that rug, every other livable surface in the room was covered with blood, including the ceiling. So there you go. That's two sides of the coin here, and I'm just wondering if Court TV has anything interesting going on. It's Court TV. Court TV has some in-court stuff. We'll look at that, other than just the blank law and cuck screen. But while we're doing that, let's bring up a little blurb here from Court TV.
In 2 days.
Here he goes. Go right back.
Rosalia Gutierrez and Sadie Beecham were dating. They were just a few months into a new romance. But on May 19th, 2020, Beecham became worried when she had not heard from Gutierrez in 2 days. When she went to check on him, he was nowhere to be found. But what she did find prompted her to call police.
You will have difficulty finding a piece of furniture or a child's picture or a piece of child's artwork or a child's toy or a square foot of carpet that does not have blood.
Police officers dispatched to Gutierrez's apartment found blood spatter throughout, doors, walls, ceiling, and a large pool of blood on the carpet. A detective says this crime scene is consistent with a person lying in the area and bleeding heavily over a period of time, and that it appeared that the person was struck multiple times with an object. Investigators say blood from the scene was a match to Gutierrez. Sadie Beecham pointed police to her ex-boyfriend, Zachariah Anderson. She allegedly told investigators he was jealous of her new relationship and had stalked and spied on her. Detectives tracked some of Gutierrez's movements during May of 2020 to Gutierrez's apartment, as well as a state park with a deep quarry of water. Despite their efforts to locate Gutierrez's body, police have not been successful.
As a man, Rosalio Ocho Gutierrez Jr. had a personality that drew people to him. He was an optimist with an infectious laughter and a beautiful smile.
So now we're getting into more of the prosecution side of things. Just have to stop it here a little bit to make some transformative comments.
Meanwhile, his family is in mourning as questions about his whereabouts go unanswered. While police don't have a body, they do have a suspect in his death. Zachariah Anderson is charged with stalking, first-degree homicide, and hiding a corpse. Last year, Anderson's case went to trial at the Kenosha County Courthouse with Judge Bruce Schroeder presiding. Anderson's defense argued there is not enough evidence to put Anderson at the crime scene and that Beecham is exaggerating the friction in their relationship.
The facts and the evidence in this case will show you that Mr. Anderson did not kill Mr. Gutierrez.
Controversy over a witness's testimony prompted Judge Schroeder to call a mistrial to give each side more time to investigate the claims of the witness. Anderson maintains his innocence and hopes this do-over will clear his name, while the Gutierrez family prays for answers and justice.
Well, all right then. That's it. And looking over at Law and Crime, the explanation given for the lack of law and crime is that the right now they're having off-the-record conversations that are related to the motion that will be ruled on before the jury comes. So they're not having off-the-record motions. They're just talking. They're having off-the-record conversations about the motions. So I guess while we're doing that, we can scroll back and do some super chatting. Want to make sure we get all of these. Don't want to not get super chats. See, I know we did this one already. Life According to Martin said, then drink mead shots. As I said, that's just not going to work because the alcohol content is just way too low. And there is one other comment here. Jeff, can you explain the Jones Act? It makes no sense to me. It doesn't make sense to a lot of people. That's a rather detailed and involved bit of U.S. maritime law. Not exactly the thing to talk about today, but perhaps Sunday. Occasionally on Maritime Monday, we have to reference parts of the Jones Act. But we'll take care of things as they happen. So, all right, we're just kind of hanging out here, I guess, until it starts. Well, I have brought my tea, and I realized that I have not brought anything to put the infuser in. Hey, that's me. I even boomered my tea, dang it. Because that's how I roll. I know what I'm going to do. I will invert the lid. There we go. I'm smart. Okay, everybody. So we've got some time to kill here until the court shows up. So I guess it's open topic until then, or I don't know. We can stream a bit of the Murdoch trial if that's what you want. Yeah. Let me put up a little scroll here. First of all, oh, never mind. We're back to the court feed. Let's go. Nope, they've just faded out again. Thanks, guys. All right. Well, I guess we're back to open days here. We're back to open topics because law and crime is so awesome. Well, I guess it's not law and crime. It's not law and crime's fault. We still have more viewers than they do. We've got 336 and they have 302. So good for us. We're winning. We got to keep ahead of law and crime. Okay, now they're bringing the camera back up. Let's do that. All right. We'll just keep it down here while they see, and they're saying the same things we are. I lost interest. You can't see that, can you? They're saying some of the same things we are. Oh, and law and crime is buffering. That's not unusual. I lost interest in Alex Murdoch. Yeah. Does anyone know who the judge in this is? Yeah, the Rittenhouse judge. I'm trying to watch multiple trials. It's sort of the same things that we're all saying here for each other. Now, why we're buffering is beyond me, because it's law and crime. It's a feed offline. I don't know. You tell us. So, all right, we'll go back to continuing to wait for something to happen here. Sorry about doing all of this, but come on, guys. Come on, law and crime. Make up your minds, please. Are we going to do it or are we not going to do it? Oh, hey, cool. We get to watch Law and Crime reboot their computer. Their own stuff. Their own stuff is buffering. That's funny. Whoever's controlling the feed. No. See, and you thought I was boomering this stuff.
Regarding the public records of anyone involved in this case. Any information that you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your
jury
experience
instructions
as a juror while you are serving on the jury. Do not use a computer, cell phone, or other electronic device with communication capabilities to share any information about the case. Do not communicate by blog, email, text message, Twitter, or in any other way on or off the computer. Do not permit anyone to communicate with you, and if anyone does so, despite you telling them not to, you should report that to me. As I discussed yesterday, it may be tempting when you go home in the evening to discuss this case with another member of your household, but you must not do so. The case must be decided by you jurors based on the evidence presented in the courtroom. People who are not serving on this jury have not heard the evidence, and that's true even if they are watching it on a video. I can tell you from a lot of experience that they don't cover everything. There's some witnesses that are pretty routine and whose testimony is quite expected, but is necessary for a full consideration. So sometimes they won't carry that live. They have other obligations and they interview people and they have their commercials that they have to run to support the service. So
that's the defendant there.
Even if members of your household have been watching all day, that's where the danger is greatest of discussing the case. And remember what I said yesterday, just cut them off. I can't talk about the case. And the judge said, if I do, we're both going to be in really bad trouble. And fortunately, I've never had to carry through on that, but this is not the time to start. After the trial has been completed, you are free to communicate with anyone in any manner. You can talk as much or as little as you want to others about it with no restrictions. And you can watch anything that you can locate about the trial. And as I indicated yesterday, don't be looking for yourself because it is absolutely prohibited under the threat of contempt for any image of any of the jurors to be taken or published. These rules are intended to ensure that you remain impartial throughout the trial. If any of you has a reason to believe that another juror has violated the rules, you should report that to me. If jurors, well, you are to decide this case solely on the evidence offered and received at the trial. Evidence is defined first as the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, any exhibits which have been received, or are received, I should say, whether or not they accompany you to the jury room. And third, any facts to which the lawyers agree or stipulate, or which I direct you to find. And I do know that there are a number of stipulations that will be read to you regarding facts. And a stipulation is where they agree to a certain set of facts, and it won't be necessary for them to bring up other proof. Attorneys for each side have the right and the duty to object to what they feel are improper questions asked of witnesses and to the receipt of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection is made. By allowing testimony or other evidence to be received over objection, I do not mean to indicate any opinion about the evidence. You jurors are the sole judges of the credibility of the witnesses and of the weight of the evidence. You are not required to take notes, but you're welcome to do so if you wish. You may not take any notes during the opening statement or the closing arguments. If you decide to take notes, please take care that it does not distract you from carefully listening to and observing the witnesses. You may rely upon your notes to refresh your memory during your deliberations. Otherwise, keep them confidential. After the trial, the bailiffs will collect the notes and they will be destroyed. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. You should therefore pay careful attention to all of the testimony because you must rely primarily on your memory of the evidence and the testimony introduced during the trial. It is your duty as jurors to scrutinize and to weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each, you should consider these factors: whether the witness is interested or disinterested in the outcome of the trial, conduct, appearance, and demeanor on the witness stand, the clarity or lack of clarity of the witness's recollections, the opportunity that the witness has had to observe and to know the matters and things about which testimony is given, the reasonableness of the witness's testimony, the witness's apparent intelligence, bias or prejudice, if any, is shown, possible motives to falsify, and all other factors and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it is fairly entitled to receive. There is no magical way for you to evaluate the testimony. Instead, you should use your common sense and your experience. In your everyday lives, you decide upon you decide for yourselves the reliability of statements made to you by others, and you should do the same thing here. You cannot look into a person's mind to determine intent or knowledge, which must be found, if found at all, from any acts, words, or statements, if any, and from all the facts and circumstances in the case which bear upon knowledge and intent. Stalking, as defined in the criminal code, is committed by one who intentionally engages in a course of conduct directed at a specific person, which causes that person to suffer serious emotional distress or to fear bodily injury or death to herself, himself, or a member of his or her family or household, or that would cause a reasonable person to suffer serious emotional distress or to fear bodily injury or death to herself or himself, or a member of his or her family or household, and where the actor knows or should know that the conduct will cause the person to suffer serious emotional distress or place that person in reasonable fear of bodily injury or death to herself or himself or a member of his or her family or household. This is the crime charged in the first and second counts, which is literally known as stalking. Before you may find the defendant guilty of either of these offenses, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following four elements were present. First, that the defendant intentionally engaged in a course of conduct directed at another. Intentionally requires that the defendant have acted with the purpose to engage in a course of conduct directed at the other. Course of conduct means a series of two or more acts carried out over time show a continuity of purpose. Acts that you may find constitute
It's the first day of trial. It'll take them a while to work out the bugs.
Are limited to, number one, maintaining a visual or physical proximity to the other. 2, approaching or confronting the other. 3, appearing at the other's workplace or contacting the other's employer, or
Yes.
appearing at the other's home or contacting the other's neighbors. 5th, entering property owned, leased, or occupied by the other. 6th, contacting the other by telephone, text message, electronic message, electronic mail, or other means of electronic communication, or causing the other's telephone or electronic device or any other person's telephone or electronic device, or generate notifications repeatedly or continuously, regardless of whether a conversation ensues. 6M, that's the statutory number, subsection. Photographing, videotaping, audio taping, or through any other electronic means, monitoring or recording the activities of the other. This subdivision applies regardless of where the act occurs. 7th, sending to the other any physical or electronic material or contacting the other by any means, including any message, comment, or other content posted on any internet site or 7M, sending to a member of the other's family or household, or any current or former employer of the other, or any current or former co-worker of the other, or any friend of the other, any physical or electronic material or contacting such person by any means, including any message, comment, or other content posted on any internet site or web application for the purpose of obtaining information about, disseminating information about, or communicating with the other.
How does this judge make jury
8,
instructions sound so
placing an
interesting?
object on or delivering an object to property owned, leased, or occupied by the other. 9th, delivering an object to a member of the other's family or household, or an employer, coworker, or friend of the other, or placing an object on or delivering an object to property owned, leased, or occupied by such person with the intent that the object be delivered to the other. The second element of this offense is the course of conduct would have caused a reasonable person to suffer serious emotional distress or to fear bodily injury or death to himself or herself or a member of his or her family or household, and that would cause a reasonable person to suffer serious emotional distress or to fear bodily injury or death to himself or herself or a member of his or her family or household. Suffer serious emotional distress means to feel terrified, intimidated, threatened, harassed, or tormented. This does not require that the other receive treatment from a mental health professional. A member of the family is defined as a spouse, parent, child, sibling, or any other person who is related by blood or adoption to another. Member of a household means a person who regularly resides in the household of another. To determine whether this element is established, the standard of what effect the course of conduct would have had on a person of ordinary intelligence and prudence. Let me start that over. To determine whether this element is established, the standard is what the course of conduct would have had on a person of ordinary intelligence and prudence in the position of the other under the circumstances that it existed at the time of the course of conduct. The third element of the first and second offenses is that the defendant's acts caused the other to suffer serious emotional distress or induced fear in of bodily or induced fear.
It's almost like a lawyer wrote this document.
Excuse me just one second.
Grandpa remembered to get his go-go pills this morning. You don't want to get Bruce Schroeder angry. Yeah. I hope one of the lawyers didn't make a large error in typing up jury instructions. Oh. Is he missing a page? Is there something wrong? Did someone make some horrific grammatical errors? The tension is killing me. Come on, Judge, let us in on it. Oh, okay. Law and crime, or whoever's running the show, is just going to take everything away. Yeah, Joe Choi going old school, Incredible Hulk from the old TV series. Don't make me angry. You wouldn't like me when I'm angry. A Palpatine always returns. That's the defense lawyer. She's probably wondering the same thing. Long Cock doesn't fade to black. They just cut to black for about a second. He's not mid-stroke. You can't say that. Dare I bring out the sound effects? That's probably too early for that. I'm sorry. Right. Defense lawyer, pass or smash? Smash. S's and P's in the chat, folks. S's and P's. Take your pick. And here's the defense lawyer going, okay, really, what's going on here?
The defendant's act caused the other to suffer serious emotional distress or induce fear in that person of bodily injury or death to himself or herself or a member of his or her family or household. And the fourth element, the defendant knew or should have known that at least one of the acts constituting the course of conduct would cause the other to suffer serious emotional distress or place the other in reasonable fear of bodily injury or death to himself or herself or a member of his or her family or household. The third count of the information charges the defendant with the crime of intentional homicide of the first degree, which is a crime defined in the criminal code as being committed by one who causes the death of another human being with intent to kill that person or another. Before the defendant be found guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, that the defendant caused the death of another human being. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant acted with the intent to kill the other. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant have acted with the intent to kill, it does not require that the intent have existed for any particular length of time before the act is committed. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act of killing. The intent to kill may be formed at any time before the act, including the instant before the act, and must have continued to exist at the time of the act. Intent should not be confused with motive. While proof of motive is necessary to conviction, I'm not sure I read that right. While proof of intent is...
I thought that was my phone. It wasn't my phone. It was someone there's phone, I guess.
Motive refers to a person's reason for doing something, while motive may be shown as a circumstance to aid in the establishment of the guilt of another. The state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The fourth count of the information charges that at the same time and place, the defendant hit a corpse, which is a violation of the criminal code by one
Allegedly
who hides or
hit a
buries
corpse.
the corpse with intent to conceal a crime, to avoid apprehension, prosecution, or conviction of a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, that the defendant hit a corpse. Second, that the defendant hit a corpse with intent to avoid apprehension, prosecution, or conviction for a crime. This requires that the defendant have acted with the purpose to avoid apprehension, prosecution, or conviction for a crime. To each of these four counts, the defendant has entered a plea of not guilty, which is a demand that every material element, each element of each crime be proved beyond a reasonable doubt. In reaching your verdict, examine the evidence with the utmost care and caution. Act with judgment, reason, and prudence. The defendant is not required to prove his innocence. The law presumes every person charged with the commission of a crime to be innocent. This presumption requires a finding of not guilty, unless in your deliberation you find that it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the innocence of the defendant, you must do so and find him not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or want of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. Examine the evidence and search for the truth, giving the defendant the benefit of every reasonable doubt. Would you swear the jury, please?
Please stand.
All right, let's swear him in.
Do you and each of you swear that you will and truly try the issues joined between the state of Wisconsin, the plaintiff, and Zachariah Anderson, the defendant, and unless discharged by the court, give a true verdict according to the evidence given in court, so help you God? Thank you. Please be seated.
Thank you. Okay, folks, we'll hear now the opening statements.
All right, we are going off to the races
The
here.
district attorney, perhaps both parties. Sometimes you'll hear the actor or actress judges on TV talk about opening argument. There's no such thing. These are opening statements. They're intended to be brief roadmap, I guess, to highlight for you things that the party explaining what it is expected will be proved, and the district attorney will lead off. And after he's completed his remarks, then the defense has the opportunity to make opening statement now, or if it is preferred by the defense, they can reserve opening statement until a later point in the trial. Again, they're not intended to be argument. That'll come at the end, the closing arguments. And then the lawyers will be trying to convince you. Well, of course, they're always trying to convince you, but they're going to be exhorting you to come to a specific verdict. But these should be generally expected to be brief and informative of what they hope the evidence will show.
So that's a good roadmap that the prosecution and the defense should just make the opening statements a roadmap to tell you what they are going to show you as the trial goes.
Ladies and gentlemen, Judge, ladies and gentlemen of the panel, thank you first of all for all your service. Can everybody hear me?
Which comment, Flux?
This will be several days. There'll be a lot of difficult and some emotional testimony.
And real quickly, nothing was overturned on appeal. The first case was dismissed due to a mistrial.
This case has a lot
this
of
guy
moving
didn't turn
parts,
over information to the
asked
defense.
that it be brief in his discussion with you. I fear that I need to cover a number of things with you, so I'm going to take the time that I believe that the evidence demands to try to give you a roadmap as to what I believe you will hear in terms of evidence in this case. I start with what I understand Sadie Beecham will share with you. Sadie Beecham, I think, will tell you that on May 17th, 2020, she felt her life was finally about to change. She had with the defendant last in 2012. So this was 8 years later since she had last lived with him on a regular basis. They had 3 children together. She will tell you that he basically came and went as he pleased. He had a different household. He did not pay on any kind of regular basis. Sometimes he showed up on weekends, and yet he expected and anticipated that they were in a relationship and that simply was going to be enough. In December of 2018, she didn't want to live that way anymore. And so for a variety of reasons, they broke up. And so that relationship, that separate houses, you come when you want, when you mess up, you just beg me for forgiveness or do a gesture that tries to get the same situation where you're always in control, was going to be over. And so for a few weeks, they didn't have any contact. And then slowly but surely, the defendant wanted to have visits with his kids, which of course was fine with her. And he was able to get back in touch with her on a regular basis, trying to get back together with her. Again, trying the cycle of trying to get forgiveness and everything will change. But this time she wasn't going there. It doesn't mean she wasn't nice to him. Doesn't mean there weren't times where she tried out of kindness to explain why this relationship was not happening. Doesn't mean she didn't have feelings for him in some way, shape, or form based on their history. But she was ready to move on. And by February 17th of 2020, she was on a dating site and she met somebody where she thought maybe this will go somewhere. The person she was in contact with was Rosalio Gutierrez. Now he was from Kenosha, so there was that was a drive to sort of see what she was going to be able to make of this. But he seemed to love his kids and to have a relationship with his kids, and she liked that it might go somewhere. Now, this is the early weeks of this maybe relationship, right? It's not exclusive. And so she doesn't feel like she wants to share that yet with her 11-year-old who turns 12. And she certainly doesn't want to share it with the defendant, who is her ex. She knows him, and is right in the sense that what I'm going to talk about next in the evidence, I'm going to ask you to look for a certain pattern. I'm going to ask you to consider whether the defendant, as I outline the next grouping of incidents, is an individual who shows by each of these incidents that he is overwhelmed with jealousy. You'll hear a number of communications where that is clear even from his own mouth, and that he has an overwhelming need in that jealousy to be in absolute control when it comes to Satan. Each of these incidences can be characterized as a gesture where he demands control, and as he loses control, we'll talk about what the evidence shows comes next. More and more irrational each time, more and more disturbing. And then I'm going to ask you to take a look at whether the defendant in each of these incidences shows you his determination to have absolute control by using every tool available. Using human spies, a person named Steve Lentz, he texts as a lookout for him. Age 11 and 12 will tell you I was recruited by him as essentially a spy. And that he's willing to use electronics too. Basically, every way you can spy on another individual, the defendant was employing in regards to Sadie Beecham.
Well, there better be evidence to back that up.
So let's talk about each of those incidences briefly. April 24th, and this is just a 1-month period where the defendant slowly but surely learns no matter not get control. And so what culminates at the end of that about a month-long period is Rosalio Gutierrez no longer being alive to anybody who cares about him, to anybody who knows him. So I start with April 24th. The defendant has his 3 children with Sadie at his house. So he has his 11-year-old daughter, whose birthday is going to be the next day, and his 2 4-year-old twins at his home. As he is the only adult there. Sadie does not have the kids on that day. So what Sadie does is invites her new relationship, Rosalio, to come over to her home. She has no children there. She's a consenting adult whose children are at their father's. She invites Rosalio to her home. In the middle of the night, she's awoken. She's awoken because her doorbell rings. She looks out and she sees a vehicle that looks like a vehicle that the defendant owns squealing away. The next day, Rosalio and her discover that Rosalio's truck has been entered. A letter has been taken from that truck, as well as his car registration, a registration that has his stepfather's name signed on it as the person who signed, I believe, the title, the registration. That's missing from Rosalio's truck. The 11-year-old daughter then, by the time police talk to her, she is 12, says that in the middle of the night, she went with her father to the home of her mother, who she normally lives with, Sadie, that her father peeks in the windows at that location. The daughter says the two twins, age 4, are left at his house unsupervised. She actually says, I didn't feel that was safe. She says her father, the defendant, gets the paperwork out of this person's truck. She says her father, the defendant, takes a listening device and puts it in a vent at her mother's home. She says that he summons her over, and she is encouraged to look inside the window of her mother's home. And at that time, she sees her mother and a person she's never met, she hasn't seen before, who she now believes to be Rosalio, in that, I believe, living room of her house through the window. Her father's instructions are,
I believe that's his ex-girlfriend.
Be sure you don't steam the window up because they might be able to see it. Oof. This is the middle of the night for an 11-year-old girl the day before her birthday, when a rational mind might be making sure everybody had a really good night's sleep, anticipating a party or a celebration the next day. This is how the defendant chooses to conduct himself. He admits to law enforcement that he had a premonition that something was going on over there, and not only does he admit he went there, but he admits that he encouraged or helped his daughter look in that window. He denies that he put a listening device in. He denies he left the 4-year-old twins behind. He says he brought them along in the middle of the night.
Okay, none of this
rang
means
the
murder.
doorbell, needing to show in a gesture, I'm still in control. You'll hear that in the defendant's phone when law enforcement apprehend him. In his phone, they find a screenshot that has a section of the registration of Rosalío Gutiérrez on it. It has the signature section for the person who is Rosalío Gutiérrez's stepfather. And in handwriting, which the daughter will tell you is my father's handwriting, it has Rosalío Gutiérrez's home Kenosha address written down. Now, the event I've told you about on April 24th occurs at Sadie's home. The defendant, of course, knows Sadie's home, right? He's been there in the context of the children, etc. This is new. This is information about Rosalío Gutiérrez's home. You'll hear Sadie Beecham indicate that also during this time period in April, she finds Olivia to have a phone she didn't know that she had. She looks in the phone. She discovers and knows that it's the defendant, one of the multiple phones the defendant utilizes. And you'll hear both Sadie and Olivia describe multiple phones. The defendant has a phone that he uses primarily, but he has a couple of other phones, one in particular used to record. She's looking at one of those phones, and she sees the defendant has ordered 2 tracking devices from Amazon. They are auto tracking devices you attach to a vehicle, and that are voice activated recorders as well. So they have dual purpose for spying missions. Electronics to help you spy. So by now, Sadie has heard from her daughter that there was this invasion of her privacy on April 24th. She knows trackers have been purchased by the defendant. She knows through a number of texts how jealous and irrational he is regarding her beginnings of a new relationship. He is describing Rosalío Gutiérrez as beaner, booger, using all sorts of abusive names and terminology for him.
Booger is abusive?
On May 8th,
okay.
Sadie again does not have the children with her, and she is going to Rosalío's home. And based on the suspicions of what I've talked about that have occurred in the last couple of weeks, she thinks to herself at some point, you know what? He's probably tracking me. And so she searches her car, and she finds hidden under the car seat of one of the twins a phone that she knows belongs to the defendant, and it's on, meaning it would track her location. On May 8th, she drives to Kenosha. She turns that phone off. There's then a controversy between her and the defendant where he says, well, I just lost that phone. That phone must have toppled out of my pocket when I was working the car seat for one of the twins. Well, we know from looking into the electronics that he was using that phone and using an app he had just loaded on his phone recently, Find My Phone, to track her that very day. And so the things he told her about the circumstances were simply untrue. Instead, we know it was an app that he was using on that phone, connected to that phone, to figure out just where she would go on May 8th. Every time she brings this up, he acts like she's crazy. He acts like all the facts are false. But when you go into the electronics, when you go into his actual phone or computer, when you talk to Olivia, all the things she suspected and thought are actually true. The defendant is again and again fundamentally dishonest with her, acting as if these are all in her head or are accidents. Let's talk about the continuing escalation that this pattern that I've described shows. On May 13th,
wow,
Sadie again, does not have the children. Again,
There's
is
still
a
people in the
consulting
States that wear
adult.
masks.
She decides to go down to visit Rosalio at his home address in Kenosha. Now, I want you to understand what we've talked about. April 24th, May 8th, and now May 13th. Because we are talking about just weeks, just days before Rosalio Gutierrez at this same location is never again seen by those who love him, is essentially dead to those who love him. So now May 13th, we're 4 days away from that fateful day. On May 13th, Sadie goes down to Rosalio's. She is going down for food and to watch some movies. On the phone of the defendant, when taken into custody, on that phone, we have in the phone recordings of directions that look like GPS type directions, which direct you. They are deleted, but they are recovered. We don't have every one of them, but the pattern of them gets you to Rosalio's address. This is the defendant's phone that is traveling per those directions that were deleted to Rosalio's home on the same date Sadie has gone down there. Now, Sadie is in Rosalio's home. And I want you to picture this, that this is what the evidence will be.
Okay, well, the evidence better. I like when they say this is what the evidence will be. Hold them to it.
You start your meal and you're sitting down to watch something on TV. Rosalio says something specific to her about, do you want to watch this or something else? Conversations that many of you have had as you begin to start your meal. Suddenly, right after it comes from the lips of Rosalio Gutierrez, she receives a text on her phone. The text is from the defendant. And the text is an exact quote of what Rosalio just said to her. It's an exact quote that he's just texted her. Now, he tells her later, oh, that's an accident. I didn't mean to text you. That was just an accident. But his phone at that moment in time is going off a Kenosha tower, not a tower by his home in the Mequon, a Kenosha tower, and it's the tower closest to where Rosalio Gutierrez lives. So not only do the directions get him there, and by the way, have him arriving at the right time, but his phone places him at that location, quoting what is being said inside. I must be in control. Every gesture has the same pattern. I must be in control. By the next day, May 14th, we are now literally 3 days from Rosalio Gutierrez being dead to everyone who knows him. May 14th, the defendant now is looking for a confrontation based on his text messages to Sadie. May 14th, 4:13 p.m. You want me to stop by to meet Junior tonight? 4:41 p.m., a half hour later. Still not off this topic. So you're saying I can stop by and meet someone later. Now, none of Sadie's communications are inviting him over. Let's make peace. Let's talk. Why don't you come on over? Why don't you two meet? This is the defendant attempting to provoke, but revealing his intentions. This is a communication suggesting I am looking for a confrontation. Here's what Olivia says about the period we've talked about so far. She says, every time I and the twins come over, this is the daughter, I apologize. This is the daughter, age 12. Every time we come over, he leaves and goes to follow mom. Every time we kids come over. She says to law enforcement, I am his spy about Mom. I did it to please him. Here's a plan that she describes, age 12, to law enforcement that the defendant has cooked up and convinced her to be ready to implement. A spy operation. You ready? The 12-year-old says, on an occasion where I and the kids are brought to my dad's house because it's a visit, and where I know that my mom is going over to Rosaleo's home, the plan is I will call my dad and pretend, that my dad will drive us kids back to Mom's house, which of course would be unoccupied, right? Because Sadie would have gone to Rosaleo's home. So my dad will drive us back to the unoccupied house. It's important I keep a key so that I can get in even though Mom's not there. I and the twins will go into the house, and then I will call my dad and tell my dad, even though he's just dropped me off, hey, Mom abandoned us and left us alone. This is the 12-year-old telling law enforcement that this is the plan that the defendant devised for her, his spy. And she said, at that point, my dad would report this. He would report that my mom had left us abandoned. That is the lengths that we're willing to go to get control, to end this relationship. They call it the plan. It's discussed multiple times. Now, on May 16th, 2020, one day before Rosalío Gutiérrez is never again seen by those who love him, May 16th. Remember, I told you on May 17th how full of hope Sadie was. Well, here's why. On the 16th of May, Sadie gets a communication from Rosalío saying to her, would you like to come meet my kids? Rosalío has a boy, 11, and a girl, 8. They're at his house for the weekend on the 15th and 16th, and she's being invited for the first time to meet his kids. And they go for ice cream. And I think Sadie will tell you that this is a truly meaningful moment in her life. Still today, when those few hours she spent with those kids and Rosalío. She left for the night. She didn't spend the night. It was the last time she ever saw Rosalío Gutiérrez. But it meant something to her because it's not an exclusive relationship, but it felt like her hopes that this relationship was going to build and get bigger and get better.
It wasn't an exclusive relationship. That's interesting.
For her, it felt like this really mattered. Here's how the defendant was handling that same bit.
Yes. Oh, come on. This is a long one.
You race down to Kenosha every chance you get to lay down with some Down syndrome Mexican version of your father.
Yikes.
That's a text from the defendant to Sadie trying to impose himself in this real moment in her life. He's texting spy Stephen Lenz, who lives just close enough to Sadie that he can see if cars are in her driveway. So he's a good lookout, right? He's a good lookout post. This is the defendant to Stephen Lenz on May 16th, asking if she has a car in her driveway. Remember, she doesn't have the kids. So whether a car's in her driveway or not is frankly none of his business. But his spy is being employed that moment. So on the 17th of May, that's the day after this big moment where Sadie met his kids. And Sadie has said throughout this case that it feels like the defendant is some way monitoring all her communications. Everything that she's communicating with Rosalillo feels like the defendant seems to somehow know it in real time. And no one knows how that happened. That's how it is. So at 1:52 p.m., this is literally 8 hours before Rosalillo Gutierrez is gone and dead to everyone who knows him. 1:52 p.m., Sadie texts Rosalillo. Sadie says to him in the text, "I want to be yours and get more serious with our relationship." Okay, that's how she felt after she met his kids. That's her putting herself out there, right? Not an exclusive relationship, but here it is. So there's some text back and forth. Rosalillo calls her at 8:30 p.m. that night. This is an hour and a half before he's never seen again.
Nobody.
And she misses that call. His last text to her is at 8:36 p.m., his phone to her phone. She never hears from him again. She tries him on the 18th of May. This is a relationship where they are in communication in some way, shape, or form several times a day during this period of time. On the 18th, absolutely no communication from him. On the 19th in the morning, still absolutely no communication from him. And so finally, she jumps in her car and she drives from the Milwaukee area on that morning. What is going on? Trying to figure out what's happening. And she gets to his home in Kenosha. And she finds that the sliding door is open. You'll see in the pictures, Rosalillo Gutierrez has that apartment in an apartment complex that's the bottom floor, and his slider and his screen face right onto the road. So the sliding door is open, the screen is closed, and she looks in, and boy, does she see a lot of blood. And she calls 911. And at the moment she calls 911 and law enforcement gets there, there will be a number of things that law enforcement focus on in their investigation. And I'd ask you to think about these areas of focus as you think about the evidence as it comes in this case. One area of focus is, when was Rosalillo Gutierrez last alive to those people who know him? The second area of investigation is, who has the motive and who has any pattern of conduct where they would be a person we should look to as a person who might have finished that pattern, completed that pattern, or acted on their motive and ended Rosalillo Gutierrez's life. And then the third, of course, area of investigation was, where is the body of Rosalillo Gutierrez? And I'm not going to belabor that in this opening. You'll hear about very substantial efforts in many jurisdictions involving many agencies to look for the body of Rosalillo Gutierrez, which is never found. So on May 19th, okay, so this is 2 days after Rosalillo has last been heard from, at 11:07 a.m., the Kenosha Police Department is at Rosalillo's address. And they find through their investigation before too long that the last person in touch with him appears to be a woman whose last name is Macias, who received a text from him at 9:27 p.m. on the 17th, okay? And then she texted him back because she arrived at a building she thought was his. Turns out she was at the wrong building, but she thought she was in his building, and she calls him and texts him multiple times over the next half hour. Where are you? She'd never been here before. Are you coming out? You know, that kind of stuff. And there's never again an answer. So sometime after 9:27 p.m. The state's going to suggest to you all that blood results, and Rosalío Gutiérrez is no more, to those who know him. They go through family and friends, and no one has heard from him since that 9:27 p.m. time on May 17th through any other method of communication. And so law enforcement focuses on Sadie Beecham. Remember, she called 911. She's still at the scene. She is distraught. She's shaking. She's overcome. And she's really focused. Members of the jury, you'll hear the officer testify. She's really focused on getting her kids safe. She's afraid that the defendant has done this and that her kids might not be safe because of what she sees. And so she is allowed to prioritize that, and then this investigation, of course, continues. Rosalío's vehicles are still at the residence. His keys are there. There is a large amount of blood all over his residence in several rooms. The outer hallway, including outer hallway in a way, suggests that that door opening into the hallway was open at a time when significant bleeding happened, including sprayed blood, blood that looks like it's impact type of blood. There's blood then right inside the door, as if someone is now in the apartment and they are continuing to have some sort of intervention or attack happen where their blood is spraying. That blood is all over that now closed door on that interior. It is all over the rug area there and on the walls and on the tables. It extends to the dining room table. It extends to the chairs on the dining room table. Some of it hits the laptop. Some of it is in the kitchen counter. Some of it is pooled blood throughout that area where you are first in the entrance. There is a small stick of processed wood, like a baseball bat or some other hard object. It's not a log. It's not a piece of cut timber. That piece of wood ends up having blood on it, which is found to be the blood of Rosalío Gutiérrez, and hair on it as well, which is also found to be Rosalío Gutiérrez. There is significant blood on the curtains, which are on the entire other end of the apartment from where that entrance to the hallway comes. There is
other evidence
blood
of him?
on the fan. There's blood on the ceiling in multiple rooms of this apartment. There is pooled and seeped blood into the carpet in the living room on the floor area, and seeped blood, a significant quantity of seeped blood on the couch that is the primary couch in that living room. And in the middle of the area by the couch, there is a missing area where there's blood surrounding it, but then there's a rectangled off area that has no blood whatsoever. It's pristine, which certainly suggests to anybody who looks at it that an area rug, a medium sort of size area rug, was there when significant bleeding happened and is now missing from that apartment. There are little splinters of wood on the couch that are also there, interspersed in the blood and interspersed in hair that is located, strands of hair located on that couch as well. Law enforcement tests several locations at various places. You'll hear where they tested. Each time they tested and they found that it was blood, each of those times the blood came from one individual, and that was Rosalío Gutiérrez.
Okay, so no blood from him.
You will hear that the blood is sprayed, meaning there was impact in multiple locations and multiple different times based on where the blood is located and how the blood presents or looks when law enforcement is present. Remember, present 2 days, about a day and a half after the event. Again, that area rug is completely missing. You'll hear that you might hear some testimony about something.
No, you will hear.
called
You might
arterial
hear.
spray, where there's a finer.
Don't say you
misty,
might hear something.
place
That's
there
what we
too.
are going to
So
hear.
some of what you might hear is blunt force trauma, hard objects hitting a bleeding surface. Some areas that you might hear about are more likely, or at least are possible areas where maybe a knife or some sharp object penetrated someone as opposed to blunt force. Rosalillo's own phone records say that he dropped his kids off because he had them that weekend. He dropped them off on the 17th. And then he went home, and he was home by 9:08 p.m. So just within an hour of when he's never seen again. Opened a beer, drank a beer. I think maybe opened a second beer. Was expecting this Miss Macias to arrive. His TV was on, and his phone it goes off at 10:30 p.m. around, and that's found several days later, hidden in his freezer. His phone and his credit cards are behind all the items in his freezer, hidden there. In the cold, the phone goes off. The last time that phone is on in any way, shape, or form is around 10:30 p.m. on the 17th. Rosalillo's keys are there. His wallet has ended up on the couch over some areas that already had blood, so it was placed there after the bleeding occurred. As I said, his credit cards were found in the apartment.
This is interesting.
There's been no evidence that his credit cards or his bank accounts or any other identifying pieces of that type have been used ever in the 1,018 days since. The home, you'll see the pictures, is filled with pictures of his two children, 11 and 8. He didn't miss gymnastic events. He was an enthusiastic baseball coach for his 11-year-old.
So?
You will hear electronic media
literally
talk about his excitement and planning for his coaching of his 11-year-old that will be starting literally just days, certainly weeks. Baseball season is right around the corner, and watching his son play baseball was one of the true pleasures of his life. 2 days after he is gone, he has in his date book, his planner, that he is going to be at Camp Timberlea with his children. Some of you may know that local summer camp. That's a 2-day. That's an experience that's supposed to occur on May 9th.
Are you saying he didn't kill himself, or are you saying this guy did it?
He never arrives. He never accounts for this with his kids. Obviously, he never coaches baseball. In fact, neither of his kids, who talked to him all the time, who saw him every week, who were in contact with him multiple times a week. You'll hear that his 11-year-old son spoke to him during this time period multiple times per day. And there was never another split second of communication, and has not been for 1,018 days. He has missed their birthdays. He and his mother had a very close relationship. Exactly. Very close. And he has missed all of her important occasions.
Well, the purpose of this is to say he didn't run away. He's not running and hiding somewhere.
And the kids he was so devoted for. Never ever before missed.
That is just circumstantial evidence of his death, not that he did it.
Never out of touch his entire life with the people who cared about him, and not a peep from him since. So I'm back to who the police should go to first. The defendant has actively admitted to Sadie that he is jealous, that he has admitted to Sadie, and then finally to law enforcement, that he took his 11-year-old, as I mentioned, to the mom's home. He has a recording of that incident in his phone, brief recording of that in his phone. And so law enforcement certainly focuses on the person who has documented motive and jealousy documented. all of this is interesting because it happens while the defendant, according to a woman, his girlfriend, Christine Remsburg, is literally living or staying 4 or 5 nights a week at his girlfriend's home. So what I'm describing to you are things he is doing only when he has his kids over, if he is actually traveling around, or he is doing it despite the fact he continues to have this relationship with, when she's interviewed in May of 2020, she says this relationship has been going on about a year.
So is this opening.
He spends 4 to 5 nights a week at her house. But the motive for the defendant is to end
You
this
said it wasn't
relationship
5 or 6 times a week.
and to do anything he must to stay in control. So the defendant has his kids on this weekend of May 16th and 17th, right? This is the fateful weekend. Sadie picks those kids up in the afternoon. So in the late afternoon, she picks those kids up. And the daughter will tell you, 12 years old, the back of my dad's van, his minivan, which he used to transport us on the afternoon of the 17th, so the same day this happens, was normal. There were no bleach stains and no problems with the carpet in the back of his minivan when she last saw it on the afternoon of the 17th. So now the question is, what is the evidence that the defendant prepared for this attack, this murder? Well, one of the things he did was on May 15th, he took out $50,000 in cash from his account. When law enforcement gets there, he still has more than $46,000 in cash. You're going to see pictures of the bank bag, literally all the money still bound together.
So
he's got that, and the state will suggest to you that's in case anything goes wrong.
don't suggest, prove.
Run.
I don't care about
some
suggestions.
location to be out of harm's way or out of apprehension with that much money on hand. You'll hear the daughter indicate that when she left on Sunday afternoon, just hours before Rosalío Gutiérrez is gone, that she saw rope and duct tape, new rope and new duct tape down in his basement. It was down on top of essentially a wheelie, a desk chair that's down there. When law enforcement gets to this location on the 19th, there is a wheelie chair down there in the basement. The daughter is completely right about that. But no rope, no new rope, and no new duct tape. So the state would suggest to you that is ideal stuff if you think you need to move a person bleeding, dead, if you need to seal up a carpet, try to prevent as much bleeding as you possibly can from the body of the person you're removing from his own apartment.
Well, apparently it was covered. The apartment was
there's
painted
an
red, so
extremely
apparently
heavy
that didn't
rain
work.
Going on in Kenosha and in the Milwaukee area. Very heavy rain.
This guy's losing me.
And so people are not out and about, obviously, in the same way they normally would be. Another way that the defendant prepares is when we go into his multiple phones, we find that the phone he usually uses to contact people, the phone that he usually uses in situations, is not being answered, though it is just before and just after, but not being answered from 7:30 p.m. to 11:19 p.m. Left behind the phone that had smart capabilities that would be tracked, left that behind, and so was not able to answer the calls and the texts that come from multiple people, including his girlfriend, Christine Remsburg, who tries to contact him multiple times because she is expecting him in those evening hours to come over. She's talking about what they're going to have for dinner. She's talking about what movie they're going to watch. And finally, she basically, sometime before 11:19 p.m., says, okay, I'm going to bed. She's expected him. And he never shows up at her house and never gives her an explanation until after he would have time to drive from his home in Mequon to Kenosha, commit this crime, and get back to the Mequon area, grab up the phone that he hasn't been answering, and now texts her and says, oh, sorry, fell asleep. Fell asleep during the exact hours that Rosalio Gutierrez is never seen again.
Murdoch should have thought of that. Went to sleep at 8, woke up at 10. Don't
And then
know what
has a
happened.
very long conversation with her, like a 42-minute conversation with her from midnight to 12:49, maybe trying to get back in her good graces. Because she's back with him the next night. She comes to his house for one of the very first times she's ever come to his house. She comes to his house that night, the next night, and then the night after that, which is the night he's apprehended. So then I want to talk about the cover-up. Because a lot of times the way you can tell that somebody's responsible for something is their cover-up, right? That's a common way of determining somebody did something really bad. So officers get to the defendant in the evening hours. And so it's been 2 full days since Rosalio Gutierrez is gone to everyone who knows him. And prior to police getting there, a close couple of buddies of Rosalio Gutierrez who have heard Rosalio Gutierrez say, hey, I've got this new woman I'm seeing. Her name is Sadie. She's got a crazy ex-boyfriend, and maybe even that he broke in my truck one time, right? So when Rosalio Gutierrez is missing and the friend group begins to understand this, Michael Campbell is the type of friend who will drive to the person's house where that is suspected in his mind and just go and try to confront the guy. And so he and his buddy go there and they beat the police there because the police are still, doing the police things. And they bring up, hey, our buddy Rosalio is missing. Do you know anything about this? And the defendant claims he's not his brother. Claims he's not Zachariah Anderson. He claims he's his brother. He calls the cops. By then, these guys have already left. They're not trying to fight anybody or anything else. They're simply trying to ask a question. This guy's clearly not going to answer their question. They leave. So he already knows by that moment that Rosalio Gutierrez, this person he's focused on, who he's been to his house, he's texted a direct quote of what he said. He's done all sorts of other stuff regarding him. He's certainly communicated to Sadie many times about him. This guy's missing. When they go on the 19th and they look inside that minivan of the defendants, they find that the back is bleached. There's all sorts of bleach stains on the back carpeting. That the seats are out. Just the front seats are in. And the back third of the carpeting in that van has literally been cut out. So you're down to where the electronics is exposed. You're down to the plastic flooring under. The carpeting from the minivan is missing, is cut out. Where on the 17th in the afternoon, his daughter said, yeah, it was in there. Nothing was cut out of there. And there was no bleach. Fresh smell of bleach. Carpet cut out in the last 48 hours. You'll hear that in the early morning hours on the 18th, so let's say defendant arrives back in Mequon. By 4:18 a.m., he's searching for area stores by him and when they first open. So he puts in Menards, he puts in Walmart, he's going through all the basic stores. Which of them opens first is essentially his line of inquiry.
Okay, I've done that.
And he ends up getting a Walmart, opens at 8. This search happened at 4:18 a.m. Okay, this is now about 6 hours after Rosalio Gutierrez is last known alive. And you will decide what to make of this. The defendant arrives there just after 8, like 8:15, 8:18. It's pouring rain. It's still pouring rain, just as it was the day before. Pouring rain parking lot, not many cars. He parks as far as you can humanly park that minivan
As far as you can humanly
from
park,
the entrance.
exaggerate much.
And he walks that whole distance.
Literally on the exact opposite side of the planet.
In any of the probably hundreds of spots that are closer. He parks as far away as possible. Does he have the body still in the back of that car, wrapped in that rug?
Oh, you better be able to prove he had it in there in
He
the first
buys,
place.
with cash, bleach, rubber gloves, garbage bags, shampoo, Q-tips, pays cash, leaves, and heads over to an area where he is doing home demo and rent. He's doing some demo at a lake house in the Belgium-Wisconsin area. A little more isolated locations, not his house, in case law enforcement was already looking for him, in case the body had been discovered. This is on the 18th in the morning. Okay, just hours after Rosalio Gutierrez has never been seen. He's at that location, according to his phone, for 3 hours. And then leaves, goes to many other locations, but near that location, so within that immediate area, is a state park, is Lake Michigan, is a number of other remote locations, and hundreds of dumpsters, right? Over the course of any area in Wisconsin, there are hundreds of dumpsters where you might put the remains of Rosalio Gutierrez.
And perchance the remains of your case here, buddy.
He's got a burn pit at his house that he has smoldering when the cops get there 2 days later. He's been operating the burn pit in the pouring rain. In it are an underwear band from Fruit of the Loom underwear, jean buttons, steel-toed boot components. Did he burn some clothes that he might have been wearing on that day?
I bought
Officers
bleach and rubber
eventually get
gloves 2 weeks
into,
ago.
The defendant's
And
laptop.
trash bags.
When they get into it, they find a file that's labeled Rosalio Gutierrez Jr. So it's got his name. This is before law enforcement talks to him. I mean, you know, I'm sorry. They don't know this. They haven't been in his computer when they speak to him. But he's typed in the name, Rosalio Gutierrez Jr. In that are picture after picture screenshots of Facebook photos of Rosalio Gutierrez out socializing, but also a number of pictures of him with his kids. And we're going to show those to you to let you think about whether this is obsessive sign of dangerous behavior, to have collected these kind of photos in this folder on your laptop. It's got business info, it's got CCAP entries, it's got an electronic map that's pinned to the actual location of Rosalio's home. And then in that same file, under that same label, he's got a picture of one of these trackers. Just a photo of the tracker, you know, like a screenshot, right? Auto tracker, voice activated. That's
Of course it is Femnatal, Natalie
Femnatal. Paid for
much more interesting.
Days before. So the defendant, when law enforcement speaks to him on May 19th, knows Rosalio Gutierrez is missing, knows they want to talk to him about the possible stalking of Rosalio Gutierrez. That's what they tell him they're talking. He knows what he has been doing. He knows the facts that we've described happened. There's no way the defendant does not understand how important a moment this is. Here's his chance, if he's an innocent man, right, to talk about exactly what the details are that will exonerate him. Let's clear this up. Here's what the defendant does. When asked what vehicle he drives, he wants to stick with that he drives the Audi vehicle.
You mean the Audi?
Fact, Christine Remsburg is driving the defendant's Audi around.
Audi.
Her car's on the fritz. So he hasn't driven that car around recently much at all. In the Walmart video, for instance, on the 18th, he's driving the minivan. When he drives the kids back and forth on the 17th, he's driving the minivan. He decides to only share that he's driving the Audi.
Say Audi one more time, mother.
Why not bring up the minivan? Why not tell him right away, hey, the car I'm using is the minivan. Please go search it. Go do whatever you want. Go take a look at my minivan. Absolutely. Instead, he wants to talk about the Audi. Reluctantly indicates that the minivan is a vehicle. Oh, but anybody could drive it.
I bet he says Porsche and Nikes too.
That's how he decides to behave, knowing how important this moment is. He acts to these officers, tries to give these officers the officers the impression he doesn't even know this Mexican guy's name. I think they call him Junior, something like that, he wants to say. Well, he's written Rosalio Gutierrez Jr. in his computer. He's told his daughter the name of Rosalio Gutierrez. There's a phone message or a phone recording that he records between him and Sadie where he finally admits, okay, I told her the name. And yet with law enforcement on the 19th, he chooses to act as if this is not even a name he knows. He says Olivia gets that from a grandma, when in fact, he admits to Sadie that's not the case. He denies ever being at Rosalio's home to the officers, where we know based on the electronic evidence, both his text and his own phone, that he's there on May 13th. We know that. But he chooses to deny that he has been there. In fact, says, I don't think I've been to Kenosha. Though his phone is going off a Kenosha tower when he is directly quoting Rosalio. Then he's asked a very simple question. Again, this is the 19th. Where were you in the evening 2 days earlier? Okay? Not where were you 5 Wednesdays ago. Where were you in the evening 2 days ago? He says, yeah, I was with my girlfriend, Christine Remsburg, spent the night over there. That's where I was. Later goes off that. Later changes that up a little bit. But that's what he wants to go with. When Christine Remsburg, who has been with him the last 2 nights after he didn't show up at her house on the date of this homicide, when she's asked that question, also during this exact same time period, where was he? She also chooses to provide false information about his whereabouts. She says, yeah, he was with me, and that's completely false. She eventually is exposed because her sister says, that's not what happened. And when confronted with that, she says, okay, you're right. He wasn't at my house. So the two of them have exactly the same false information about where he was. So you are going to finally hear 2 other important pieces of evidence from the state's perspective. One is when the crime lab examines the van in question. These are people who are the experts in the state at trying to figure out whether there's worthwhile evidence and then trying to do the appropriate testing of evidence having to do with DNA in the state. And so the experts come and the van is eventually brought to them, and they go through that van and they identify a particular location that is near the back. So in that same 1/3 of the minivan where the carpet has now been cut out, but it's about halfway up and it's on the plastic panel and it's just a little speck. And when the 2 DNA and crime scene analysts, when the DNA and crime scene analysts see that, they both say, we think that's blood. But it's so small that they decide that is just going to be our observation. We're not going to use a chemical on it. We're afraid we might not get DNA if we do that. So they observe, they believe it's blood. It is taken to the crime lab. It is tested. And based on the results, again, the analyst, Lisa Treffinger, will tell you She believes it's blood. She believes that based on the process of elimination. It's not semen. It's not skin cells. It's not saliva. It's not a piece of hair. And therefore, based on the content, based on what we can get on the results, it is blood. I believe it to be blood. She'll offer that opinion.
Well, if you're confusing blood with semen,
she'll also tell you that her test
you've got problems.
Tells her that that blood is the DNA of Rosalío Gutiérrez. Rosalío Gutiérrez, there's not going to be any evidence he's ever been in this van, certainly that he's ever bled in this van, that he has anything to do with this van. And his blood, his DNA, is located on that speck amidst the area, not in the same area, but in the van filled with bleach and with the cutout carpet. Cutout carpet is never found, by the way. Clothes that the defendant was wearing on the 17th are never found, by the way.
They're at Alex Murdoch's
Then
laundry.
finally, you're going to hear evidence of an individual, an inmate named Marquand Washington. Marquand Washington has very serious federal charges that are going on right now, and he's being...
That wasn't me. I didn't do it.
You'll hear him say that several months ago, he came forward to his attorney and told his attorney that I previously roomed with, I shared a cell, I was a bunkmate with, that when that occurred,
bunkmate with who?
He bonded over some common sort of criminal activity. So, we talked, and I'm not going to talk about the details, but that they bonded over some discussions of their life prior to this date. You'll hear that Marquand Washington was able to tell details about the case, such as when the police raided
There's even
residence,
law crime saying we don't
they
want to
found a lot of money.
Hurry up, dude.
And a little bit of weed. And that you'll hear Marquand Washington say the defendant described the house that was raided as a crappy house, but in a nice area. You'll hear Marquand Washington say the defendant told him when talking about murder that murder takes a lot of work, that you have to figure out ways to track people and stalk them, learn their habits, learn what they are up to so that you can find your moment. He suggested trackers from Amazon would be something that would be worthwhile to consider. Marquand Washington says the defendant told him that he wrapped the body up and took it away, that he put the body in trash bags, that he made sure the trash was gone and so it will never be found. Marquand Washington will say, well, how did you lift that guy? How did you lift him, however you got him out of there? And the defendant told him, I was working out at that point. I was so strong, adrenaline. He said, I was like Superman.
Put this guy on the stand.
Combination of adrenaline and my working out
First question.
was what allowed him to do it.
You've been convicted of crimes. Second question.
Marquand
You want to get your
Washington
sentence
tried to get him
reduced,
to
don't
tell
you?
him, well, why?
Third question.
Why'd you do this?
So you're lying
And he
to
said
go along
he
with the
never really
prosecution
had
wants, so you get a
real
reduced
answer,
sentence,
but
right?
that one thing that struck him that the defendant told him was, my ex was getting serious with this guy, and she was happy. The defendant admitted to Marquand Washington he also had a girlfriend then, though they are no longer together during the period of time that the two of them stayed together, but he provided those details. So you'll hear about the act itself. You'll hear from people who love and care about Rosalío Gutiérrez that he is gone. You'll hear about the physical evidence, and you'll hear about the confession made. And when you combine all of those pieces of evidence, then from the state's perspective, you will have enough evidence and will hold the defendant responsible. Thank you.
Thank you, Mr. Gravely.
Looks that way, Jim.
Break. As I indicated when we broke yesterday, I had some further discussion with the lawyers about some legal issues. And then I was doing some more reading last night and have come to a decision. I've given them the decision, but I'm going to give them the explanation. So that's going to take a little more time than the usual break. I'm hoping we'll get back together in about a half an hour.
Great.
Please don't talk about the case during the break. And as you know, there are 21, I think, 21 steps to the jury room. If that's something that puts you off or is a problem, just tell the bailiffs and they'll give you directions how to get up without using the steps. Any question? Okay, we'll see you as soon as we're able.
30-minute break, eh? I hope he talks for a lot of that, and we get to see him talk about a lot of that. Because if not, the only thing we can do is go back and watch 30 minutes of that again.
Does the defense desire to make opening statement now?
Yes.
Okay, and who's going to be speaking?
Me.
Okay, and I think we will, now, do you want the break first and my legal discussion in after the break, or would you, either way? Okay.
Judge, I'd prefer to do my opening statement before.
Before the explanation?
Yeah.
Yeah, we can do that.
Okay, thank
Okay.
you.
Okay, well then we'll try to start at
You don't want to go into lunch.
about 25,
Yeah, because I'm.
about 25 after.
So we have 15
My
minutes.
watch.
Okay, so 15-minute break.
15 minutes.
15?
1-5.
Thank you.
See, I think that's a good idea. I think strategically that's a good idea what she did there. Because now, you know, she doesn't want to lose the momentum. He went, they don't want, she probably doesn't want the, you know, the jury to sit and just think about what he's been saying, She wants to get in, get her punches in, and then maybe take an early lunch and hear his rulings. She doesn't want to waste the time. She wants to get back there in the ring. I like that. All right. So, well, we've got some time here to catch up on some super chats as soon as the judge gets out of the way. But first, we have to bring in our guest, Natalie Wisco. Howdy.
Hi, how are you, Jeff?
It's been ages and ages and ages.
I know you like stream a lot at weird hours.
Yeah.
And I
Different
am a
time
sleepy
zones.
bear. So I'm usually just part of the replay crew. And I listen to you usually when I'm on my commute. So.
Oh, well. So for those of you that have no idea what an awesome, amazing superstar you are, tell us a little bit about who you are and what you do.
My name is Natalie Wisco. I am a criminal defense attorney in Wisconsin. I practice regularly in front of Judge SCHROEDER. I know pretty much everybody involved with this case, at least from the professional standpoint with the attorneys, and I was one of Kyle Rittenhouse's attorneys, so that's kind of the buzz with me.
I just do all these amazing things. Oh, and I was Kyle's lawyer. Yeah,
I don't know. I like to
like
be
it.
known
I
because
know.
I'm awesome, Jeff, not because,
Well,
you know.
Do you know why you were on Team Rittenhouse? Because you're awesome.
Oh,
that's
thank you.
that's
I
why you
appreciate
were there. It wasn't just like go down there and hire, you know, just some rando lawyer off the street. You know. It's,
Well, and
obviously
it's just funny coming full circle because the female attorney who's doing opening statements actually went to law school with me.
Oh, yeah.
The male attorneys on this, so there's 3 attorneys on the defense team. There's Nicole Mueller, John Birdsall, and Kirk O'Bear. John Birdsall is a longtime friend of Mark's. They Their office is based out of Milwaukee, but Kirk O'Bear, who is the one who's sitting on the end, I actually interviewed with before I interviewed with Mark. So,
oh wow,
yeah,
so you're just like you don't just know everybody, you know everybody.
I mean, and Kirk O'Bear is former military. He was a JAG prosecutor for years, and he told me that the reason he left prosecuting was because in his office there was a traveling trophy for prosecutor who got the most years sentenced that month, got the traveling trophy, and it kind of dawned upon him that was really fucked up. And he went over to the defense side. Yeah.
Seriously?
Yeah. No, there was a traveling trophy for, you get the trophy that much. They had like a running total of how many years people were sentenced to each month.
That's actually really disgusting.
It is. But Kirk's a great guy. His office used to at least be out of Sheboygan, which is farther north. They do a little bit more cross the state representation in lots of different places. Whereas, where we do that as well, but we're pretty much just focused in the southeastern Wisconsin area. They go a little bit farther broad than we do.
Wow. So before we mentioned it, you'd chatted it to me, you DM'd it to me, and I mentioned it. You said they're calling this the Stephen Avery 2.0.
Oh, that's what Nicole had told me about it, because I know Nicole, and she had, I think it was after Rittenhouse at some point in time. She and I were talking on the phone. She had called my office, and I'd seen that they were on the case, and I was like, good case to grab as far as good cases go. And she started telling me about it, and they referred to it. She's like, it's just like Stephen Avery. There's like, granted, I thought it was burned barrels, not a burned pit, but she had told me a little bit about it, and it's just, especially as attorneys, like entirely circumstantial cases are kind of fascinating, because it's like, how far are you going to do the mental gymnastics to make this fit here?
Well, what did you think of the opening? Well, I'm sorry. First, let me burn through these super chats. People have been waiting for since Christ was a corporal to hear these super chats, because that was just a long opening.
Yeah, that was my thought as well. Really, more than anything, is that, I mean, granted, I was in and out because I was doing a bunch of other stuff too, but it's opening is a roadmap. That's what Judge Schroeder said, is you don't need to say every single thing in the roadmap. We're going to hit
his
these things.
Roadmap was like A, B, C, D. That was just odd. But Brewerberry says, hey, Jeff, catch you on a replay later in the day. I'm just wanting to see if the cat lady pathologist is going to run at Poon with a scalpel soon. If everybody wants to watch the other trial, you know where to find it. Our purpose here is to specifically avoid more Murdoch. We've had enough Murdoch to last me a lifetime. Flux,
you need Wisconsin accents instead of Southern accents.
Yeah,
that's just what it is.
Dude staged his death to get away from her when she wanted to get more serious. LMAO, dude, that's cold. Law, the Murdoch trials made me jaded. It should make you jaded. It should make you more skeptical. There's far too much of he's under arrest, so therefore he must have done something wrong.
Yeah.
And Isaac Brooks, wholesome gabagool art says, open to beer, 2 tree beers. Oh gosh. Yeah. People are like, notes on playing Boston accent. No, that's about as Wisconsin as you can get.
I think the best way to come up with a Wisconsin accent is to focus on, as I was saying it there, focus on saying the word boat. It turns into like going out to the boat, the pier, the dock.
In Utah,
that's what it is.
We flip vowels in Utah. Like if you're where you'd say, were you born in a barn? You say, well, were you born in a barn?
Oh,
yeah. You got you eat with a spoon and a fork.
Wash. There's wash.
Yeah. We wash clothes and
clothes. And you wrap.
We have eggs and pillows and all those other things.
Oh yeah, pillows. God.
And about 30% of native Utahns, like longtime native Utahns, can distinguish between pins and pens. But of course, I'm from Utah, so cot, like you caught me, and the cot you sleep on are pronounced exactly the same.
Well, and then there's mirror and mirror, depending upon where you are.
Well, there are no vowels to it. If you don't transpose the vowels in Utah, there are none. Ignorant has ignorant is spelled IGNRNT, just ignorant. Just ignorant. Speaking of ignorant, Flux, what were you saying? Is the guy even really dead? We don't know.
Who knows? I don't know. I didn't hear anything from the state saying that he's really dead. There's a lot of blood involved. I don't know. I mean, that's not really evidence of anything else other than blood, though.
And you and Valhalla had a blood eagle conversation going. That was pretty good.
Well, I mean, that's my real problem with blood eagling in general is like, I mean, in theory, it's like, how are you supposed to stay quiet during that? But I guess that's why it's hard.
Yeah, that's kind of the point. Yeah.
Yeah.
I was so happy when they did that in Vikings because I've been just coming from good old Viking stock, as I'm sure everybody in Wisconsin does too.
Have you seen Norseman on Netflix? It's like a satire of it.
That is so perfect.
Okay. Yeah, no, I recently
so perfect.
I just got done with COVID, and that was something I was watching when I had COVID. Was I came across Norseman, and it was perfect.
Oh, that was so beautiful. I just loved every minute of that show. So I think we got all the super chats quickly out of the way there.
Yeah, something for people in the chat, just as a reminder. So the Rosario here is a man. I know it sounds like a feminine name here, but I saw people were getting confused. Rosario Gonzalez. This actually was a very big, this was a huge thing when it happened because he was like paralegal or witness client services person with the Kenosha Public Defender's Office. So it was a big thing, at least in the defense community, because, you know, this is like staff for, you know, the public state office of defense attorneys. So it was very big in that aspect, at least as soon as it came out, just with, you know, gossip and who did it type of stuff. But, you know, yet to this day, I still have to see, you know, really any solid evidence saying that Zachariah Anderson is the one who actually did it.
I don't know how,
or even that he's dead.
Yeah, I don't know how much you can talk, because I know you work with these people or against these people, but can you give us your thoughts and breakdown on that opening statement?
In general, I saw people, you know, comment. I'll just talk about some of the comments that I saw as I saw some people commenting about, you know, him maybe speaking loudly, emphatically, things like that. It is a big courtroom that he's in. That's one of the two like huge courtrooms in that courthouse. He generally is quite emphatic. So I don't think that it's an opera house presentation type thing. That's just kind of how he is. That's how he talks all the time. That's his normal type of presentation. What that tells you is what it tells you. You know, I think
I'm sorry.
No, I was gonna say, I think it's interesting that if you watched Mark Jensen's trial at all, the opening in that case was kind of similar in this weird sort of long drawn out pieces going everywhere type of thing. So I don't know if it is an office thing, but it's not uncommon with at least them. You know, I think it's detracts from the strength of the overall statement when it's that long in general, because people don't want to listen to that at this point in time. You're on a jury, you don't want to listen to a 2-hour opening. You want to start getting into the meat of the case, hearing from witnesses, things like that. You know, a long closing is fine, but I think, you know, openings for the most part, you know, people don't pay attention that long, and they're going to forget
really
what you said.
Disjointed. Yeah, it seemed really disjointed to me. It wasn't linear. Just something seemed, I guess, disjointed is the only way I can describe it.
Well, and I'm sure it probably made sense in his mind, but that is the problem is, you know, I think when you work on cases like this so long, it's really important to talk to people who aren't involved with the case. That is something, you know, I used to always do with my dad, is try to explain things to him. And he'd, you know, get to the point where it's like, well, why is this important? It's because you bury the lead. And I think that that's something that they've done here, perhaps, is if there is a lead, if there is really some strong pieces of evidence, you know, they probably should have led with that. Don't bury your lead, especially when there's so much at stake. It could have been effectuated better.
He's had a year. He's had a year to refine the opening argument, seeing as how they got the mistrial immediately after the opening statements a year ago. So I expected it to be more polished, but, you know, what do I know?
I mean, who knows? I mean, some people have to be scripted in order to maintain their thoughts, but that is generally the role that we don't like to be scripted as attorneys. Is you're supposed to be able to be adaptable and, you know, interact with people and adjust yourself accordingly. However, you know,
I mean, that's a good point. Camille Vasquez. I mean, I remember watching her give the opening statements in the Depp trial, reading from a actual paper in her hands. And I went, oh God, this isn't going to go well.
Yeah. Well, and
she
people can't hear you.
crushed it.
It's a performance as well. That's part of what it is if you think about like tone and delivery, all those things are discussed all the time by us when we look at these attorneys and their performances. That's because it is a performance in some, you know, traditional aspects of, you know, performing. And, you know, if nothing else, you know, when you look down, you constrict your ability to breathe and project, and, you know, the tremor of your voice and things like that. You know, if it's something much different, if, you know, you have like presidential, something like that, you know, like a screen that's got, you know, cue cards doing everything, but that's not anything you'd ever want to do in a courtroom, because then everybody can see.
What can we expect from the defense's opening statements? I mean, of course, you don't know what to expect from, but how would you approach the defense opening?
I think everything in general is on the defense. You have to kind of turn it into a way in its own rebuttal. That's kind of how I approach defense work is, you know, the state has its final rebuttal. The entire defense case is rebuttal when you think about it, because you're rebutting, you're going against other evidence. So personally, I like to do a lot of things like I will write down exact phrases that the district attorney said, especially if it's something that pisses me off. And, you know, incorporate that in mine is be like, you know, they've said this using their own language against them, stuff like that. I think at this point in time, you know, the best thing that the defense can do is be succinct. And, you know, I struggle with this as well, but why say 5 words when you can only say 2? And that is something that I think, you know, especially when you're thinking about the dynamics combating what he's presented so far, how it's been receptive. It's not going to be, you know, I don't think it's something that you can come back, you know, with the exact same energy that the district attorney has. I think that, you know, especially in a circumstantial case, there's going to be so many things of, well, why didn't you do this? Why didn't you do that? As far as, you know, investigation goes. So if it was me, you know, getting into it, I would look a lot at what wasn't done. That's kind of the things that I would probably focus on. You know, you'll hear about all these things. And you know what, like, you're going to hear that nothing else was done as well. You know, that nobody else was looked into, that nobody else did these things. I think something like this, you know, that can be an effective strategy to be like, well, the state's told you about everything that they think you're going to hear, but you're going to hear about a lot of things that they haven't mentioned, you know, and there's, I think that, you know, filling in the story, filling in holes is usually very effective, because then it makes it seem like they are hiding something.
There's a couple things that bothered me about the prosecution's opening. One of them is he said a few times, you may hear testimony about this.
Yeah, I noticed that too. I thought that was
I don't want to hear we might have someone to testify. Tell me or don't tell me.
Yeah.
I thought that was very weak.
I thought that was very weak as well, because it makes it seem like you're not confident in yourself. You don't tell me. You know, there is a lot of strategy and gamesmanship. There might be witnesses that you don't call because another witness was stellar. You know, especially a judge like Schroeder doesn't want you to be doing too much cumulative evidence, things like that. And, you know, if it's somebody who you think you might call, if it's important enough to mention in your opening, then you should probably for sure call them. And I think that, it looks terrible if they don't.
Go back in closing and go, at the beginning, we told you would hear this testimony, but because of this, this, and this, we didn't need to waste your time. It was no longer, it's already been established, so we didn't need to call that person or present that evidence. It's just weird to say you might hear testimony that this happened.
Well, and especially with something that's kind of an outlandish statement, because that's so easy to turn around later. Like recently, I was in a jury trial wherein they said something in opening that was completely wrong. It was something entirely small and irrelevant. But then it turns into something that you can bring in closing. I was like, the jury instructions say, and the state's going to harp upon that, your job is not to search for doubt. Your job is to search for the truth. Well, why would someone whose job is to tell you to search for the truth lie to you in the first 10 minutes that they spoke to you? Why would they do that? It's because they're hiding something, or they're trying to make, something out of something that doesn't exist. So I think you have to be very careful as the state in openings, because if you don't do something that you've promised on, it can completely kneecap you.
When there are our monthly membership chats here, they don't show up here in chat, so I have to check them out myself here. Jim Satala says, when the prosecutor said on opening that he could have cleared it all up by telling the police what happened, how wasn't that a Fifth Amendment violation?
I didn't even listen to the question. I'm sorry. I was looking at the chat.
Oh, it was one of these. It's when the prosecutor said on the opening that he could have just cleared it all up by telling the police what happened. How wasn't that a Fifth Amendment violation?
I mean, it was, but there's also, you have to think of strategy about objecting. I don't know. There is a mixed bag, and it's, people come on both sides of this. I really don't like objecting in openings. I think it just sets off a bad tone to the jury personally, unless it's something like extremely factually incorrect. But that is also a personal preference. And I think that also has to do with your delivery style as well, is, certain people can pull things off that other people can't. And a lot of people you hear skating on thin ice. Well, Mark's the type of person who will get as close to the edge as possible. Some people don't do that, though. It's a matter of, strategy and, sort of the overall performance. What works for some people doesn't work for others. And I mean, I'm not saying that it was right and that he should have said that, but their failure the reason them not objecting, I, don't think it was egregious or anything.
And I don't think the jury's going to remember that a week.
No, not at all. Anyway. That's the thing, is also objecting makes people remember stuff. Yeah. It's like that can snap their attention. It's like, oh, this was important. And it's like, and sometimes that's the last thing that you want to do is bring attention to something little.
Yeah, and that's the thing. I mean, if you watch any of these, law streams, these trial streams that involve lawyers, even ones like myself that aren't courtroom lawyers, every time anybody objects during opening statements, it's a 100% across the board, because you just don't do that.
Well, I mean, it depends, and
unless it's, as you said, it's unless there's some ridiculously important factual thing.
And I can tell you that all the opening statements that I've given that there's been an objection to, I did win in the end. I don't know if there's a correlation, but that is a random statistic. Is that now that I'm thinking about it, is every time I've been objected to in my opening, I've actually gotten not guilty verdicts. So,
and Jason J says, I'm from Michigan. You Wisconsin people say soda and bubbler. Okay.
Well, I mean, the bubbler thing, yeah, that is a little weird to me, but
yeah, all got weird things. All right, the court is coming back. At least there's people there. Now, that's not the right one. There we go.
Well, it looks like you're going to get into defense opening, so I'm going to piece it out because I got other stuff to do too. But right. I might pop in again afterwards. I'm trying, since I was out for a week with COVID, I'm trying to get all the little stuff done that I need to do that I really don't want to do done. So,
I hope I didn't hurt you.
But if there's anything interesting that I specifically want to comment on, I'll pop in.
All right, please feel free. And as long as you're here, as long as you don't mind, I will send you a link every day to join at your leisure.
That is fine. That's actually the best, because frequently I have things where it's like, man, I've got an hour before I do this other thing, and I really don't want to start something new.
Yeah.
So.
Well, all right. Well, thank you for being here, Natalie. So great to see you again.
I'll pop in again sometime soon.
Take care.
Bye.
Bye. That was Natalie Wisco, Kyle Rittenhouse's attorney, as well as a defense lawyer who is awesome in her own right, even if Kyle Rittenhouse wasn't a thing.
Don't have as loud don't have as loud of a voice as the state, so have to use the mic. The essence of this case is actually quite simple. The state just walked you through for quite some time about the evidence and how it thinks it's going to come through during this trial. But at the end of the day, law enforcement nor the state have no idea what happened to Mr. Gutierrez's body. They don't know when exactly anything happened in Mr. Gutierrez's apartment. They have no idea where any alleged remains of Mr. Gutierrez's body is. They have none of that.
Mm-hmm.
There are no witnesses that saw my client, Mr. Zachariah Anderson, at 3709 15th Avenue in Kenosha on May 17th, 2020. They have absolutely no witnesses that say, hey, we saw Mr. Anderson and he had bloody clothes or he was acting suspicious. They have none of that because none of that evidence exists. No body, no human remains, no indication of cleaning up a crime scene despite what they state occurred in that van. I'll talk to you a little about that later. They don't have any of that. Yet they decided to build a script, and the evidence will show you this. They decided to build a script and tell a story and make Mr. Anderson
Do I need to turn up the court volume a bit, or is it okay?
Despite the fact that they didn't have any of this evidence. No body, no human remains, no witnesses, nothing. If you're looking in the wrong places and at the wrong people, you are not going to find the information you're looking for. The state just talked to you at length about some of the evidence that it believes is going to come in, and that evidence is going to show you that Mr. Anderson committed the crimes as charged. And the state and myself, he explained to you kind of what opening statements are. Not going to do that. You're all capable people of understanding why we're speaking to you right now. But I'm speaking because I see the evidence a little bit differently. And when I'm walking you through the evidence that will come in today, it's not based on speculation. It's not based on some theories that are in my head where there's no evidence to back that up. I'm going to walk you through the actual evidence that will come through during this trial. But let's start with what the state kind of walked you through. That this really all stems because Mr. Anderson is a crazy, jealous, obsessive ex. The evidence during this trial will debunk that theory. And in addition to that issue, motive is not an element of the crime. In order to be threatened by a serious relationship has to exist. The state talked about how things were getting heavy between Mr. Gutierrez and Miss Beecham, that they were meeting each other's kids, that there was talk about that. What the state didn't inform you was that Mr. Gutierrez was actively dating and seeing several other women. He was not in any means exclusive with Miss Beecham. He had in fact told some of his closest friends that he was intending on breaking up with Miss Beecham. Miss Beecham had never met a single one of Mr. Gutierrez's friends. And this concept of that the state talked about how, she had never talked to her child about Mr. Gutierrez, or that information must have come from Mr. Anderson. That's not accurate. And the text messages that will come in will establish that Miss Beecham had discussed Mr. Gutierrez with her daughter. There were text messages that she sent to Mr. Gutierrez that says, Liv wants to meet your kids before she meets you. Well, obviously, she must have had a conversation with her daughter about who Mr. Gutierrez was, but still doesn't change the underlying factor that this was not a serious relationship. Additionally, from February of 2020 through May of 2020, there was consistent communication between Mr. Anderson and Miss Beecham. And that communication wasn't, oh, I want you so bad, come back with me. It was kind of a mutual agreement that their relationship was toxic. They were never getting back together, that she had guys she was seeing, and Mr. Anderson had his own girlfriend. The
He's being
timeline.
very expressive.
The state said that the timeline shows Mr. Anderson must have been involved, but the state's ignoring critical evidence as to that timeline. The state admitted May 17th, 2020, Mr. Anderson had his kids, his 3 children. They were at his home in Mequon, Wisconsin. That later in that afternoon, around 5 to 6, Miss Beecham picks them up. Mr. Anderson, then, they don't have any evidence that Mr. Anderson left his home. They claim that this is the time where he traveled down to Kenosha, but you'll hear from law enforcement officers that they got surveillance video from multiple places, not only in the Mequon, Ozaukee County area that Mr. Anderson would have had to pass to get to Mr. Gutierrez's apartment, but they also got surveillance from gas stations, schools, the transit authority, from the buses, from neighbors' ring cameras, from the area in Kenosha that Mr. Anderson would have had to have passed if he was driving. And you'll hear from law enforcement that they don't observe Mr. Anderson's vehicle. So the state has absolutely, there will be no evidence during this trial that will be presented to you that shows that on May 17th, 2020, when Sadie Beecham is at Mr. Anderson's home, she sees him there. He then texts someone at 11:19 p.m., and you'll hear from law enforcement officers that his phone pings at his home at 11:19 p.m. Nothing shows he ever left home that night. People falling asleep around 7 to 8 p.m. as adults who have children and have been with them all day, that's not unreasonable.
Fair enough.
So the next morning, he wakes up, he goes to Walmart. You'll hear evidence that Mr. Anderson's a contractor. He was going to a home up in Cedar Grove area that he was working on. He was doing lath removal and other serious removal jobs. It was basically a complete reconstruction of the property. And so if he went to Walmart and parked far away, you'll hear evidence that he likely had tools in his van. And in addition to that, he then goes to his job site for 3 hours. And the state's saying that after that, they don't know where he goes. No idea. The evidence will establish that after he was at the house in Cedar Grove for 3 hours, he went to Menominee Falls to pick up his taxes. That's a nice fact that the state didn't talk about that will come in. And what's interesting about the fact that Mr. Anderson had gone and picked up his taxes in Menominee Falls right after working at his job site in the morning is that that evidence wasn't readily given to the defense. That you'll hear that this evidence, this receipt that stated 5/18/2020 from the tax accountant services was a piece of paper that was located in Mr. Anderson's van. And that law enforcement, when they executed the search on Mr. Anderson's property, they took all the papers and put them in a pile and labeled them miscellaneous papers. And they took one picture of all of those papers and put that into discovery, and that picture's blurry. You'll see that picture.
Mm-hmm.
It wasn't until the defense asked to see that documentation that we saw this receipt that proved that Mr. Anderson wasn't for hours getting rid of a body, but was going to pick up his taxes in Menominee Falls. And you'll hear from the accountants that he was there. You'll also hear from them that they had video surveillance, that law enforcement, had they gone and talked to these people, would have been able to get that surveillance video to see what Mr. Anderson was wearing, the fact that he didn't have any blood on his clothes. And then after he picks up his taxes, he goes back home and spends the night with his girlfriend, Christine Remsburg. The next morning, they wake up. It's a normal day. But it's not normal for Mr. Anderson because two random people show up on his property demanding that they speak with a person named Zachariah Anderson. And Mr. Anderson knows that he doesn't know these people. They don't know what he looks like. So he says, hey, I'm his brother. He's not here right now. What do you want? And they say, as the state noted, we're looking for our missing friend from Kenosha. And these people are snooping around his property, acting suspicious. And so what does Mr. Anderson do? He calls 911 himself and says, hey, there's these two random people that are on my property demanding to speak with me. I told them that I'm my brother because I'm a little concerned about why they're here, and they're demanding questions about their missing friend from Kenosha. The man who the state's alleging had something to do with the disappearance of Mr. Gutierrez is calling 911 and saying they're saying that I had something to do with this missing guy from Kenosha. Law enforcement responds to the home, but it's not to respond to Mr. Anderson's concerns. They're there to arrest Mr. Anderson and to execute a search warrant on his property. He's taken into custody. They take pictures of what he's wearing: white t-shirt, blue jeans. They send some of those, say, oh, there appear to be a stain on this shirt. Let's swab it and send it to the crime lab. Not blood. No DNA of Mr. Gutierrez. Oh, the jeans, looks like there's another red dot. Let's swab it and send it to the crime lab. No blood. No DNA linking back to Rosalía Gutierrez. They took pictures, you'll see these, of Mr. Anderson's hands, feet, arms, not a single scratch, not a single bruise, nothing. So the state's assertion that there's going to be evidence that Mr. Anderson had time to get rid of every single possible piece of evidence, the body, all remains, everything that he used to clean up. The state talked about some items bought at Walmart. They were 13-gallon trash bags and 2 things of Clorox wipes. Don't think that's enough to meticulously clean up a crime scene, nor is there any evidence that that is.
So Clorox wipes, not bottles of bleach?
As you'll hear, this was during the height of COVID. It was basically still almost about to be the lockdown, or actually was in the middle of the lockdown. So searching to see what stores are open before you go to a job site was not bizarre. You'll also hear that during COVID, items such as Clorox wipes and gloves were extremely hard to come by, and you would pick them up when you got the opportunity. So the timeline that the state told you, there's evidence that supplements that shows Mr. Anderson could not have had the opportunity to commit the charged offense. The other piece of evidence that the state talked about was Marquand Washington, and that Mr. Anderson allegedly admitted to him that he did this and that he stabbed Mr. Gutierrez, took his body, put it in some trash bags, and took the trash out and got rid of him forever.
Yeah.
The state talked to you a little bit about Marquand Washington. Marquand Washington is currently facing a minimum of 10 years to life.
That's what I was saying. That's the first thing you do, to lie, get a sentence
cases, when there are mandatory minimums, the only way to deviate from that mandatory minimum, so the only way to get less than 10 years is if you cooperate. If you provide information and then get on the stand and testify to that and cooperate that the government, who's the prosecutor in a federal case, can file a document to say, Judge, we're asking for lesser than that 10-year mandatory minimum. And you'll see that in Mr. Washington's plea paperwork, the government nicely outlines that in order for you to get less time, this is what you're going to have to do. Now, the state didn't mention this to you, but Mr. Washington is someone who will literally do anything to get out of his situation. That they had evidence, that the federal government had evidence that he intimidated the witnesses and victims in his own case in an attempt to get out of his situation. And when that didn't work, he was left with one option: cooperation.
Yeah, these jailhouse confessions
and in February
are weak
of
as shit.
2022, the federal government was told that he had information that he wanted to share, and they wrote a letter to him, and they said, Mr. Washington, we've heard that you want to share some information about some crimes that you have knowledge about in the Milwaukee surrounding area. Please let us know what that is. He did not mention Mr. Anderson in February of 2022, and that's critical because the state said that Mr. Anderson trusts Marquand Washington, but Marquand Washington only was housed with Mr. Anderson for approximately 3 weeks. It was a very short housing situation. And those 3 weeks was from February of 2022. Or no, sorry, I apologize. It was December of 2021 to January 31st of 2022. So in February of 22, he would have had this information, but he didn't share it then. No, he only shared it about 3 weeks in a case that's been going on since May of 2020, when he's allegedly had this information for almost 2 years. But what's even more critical is Marquand Washington, as the state says he will testify, and I'm saying as the state will say he will testify because the defense did not have the opportunity to meet with Mr. Washington. Mr. Gravely, the district attorney, and Vincent Carrera, a detective, they met with Marquand Washington, and they questioned him for an hour and 30 minutes approximately. They did not record the interview. Instead, they gave the defense a 2.5-page summary of what he would say.
A little bit sus there.
But what I do know from that 2.5-page summary is that he claims that Mr. Anderson said he stabbed the guy. The officer, the state talked about how you'll hear from officers about the blood stain pattern analysis completed in this case. That officer will tell you that he believed that the stain patterns that were seen in Mr. Gutierrez's apartment were consistent with blunt force trauma. That was his opinion just in February of last year, Officer Van Wee, and in his reports from closer to May 2020, he wrote that he believed it was blunt force trauma, so a heavy object or an object hitting someone.
There you
and
go.
Also, Detective Carrera wrote in his reports that it was blunt force trauma. There was never a single mention in Van Wee's reports or Detective Carrera's reports that the stain pattern analysis were consistent with sharp force injuries. There's a difference between blunt force injuries and sharp force injuries. Sharp force injuries is a knife. No mention of that. In fact, you'll hear that Mr. Gutierrez was an avid baseball fan, loved baseball. Not only did he love baseball, but he loved to play baseball with his kids.
Ooh,
and he was
she's going to suggest someone on the baseball team did it.
And
someone
so
in the minor
he
leagues.
had baseballs in his apartment and in his truck. He had gloves in his apartment and in his truck. You know what wasn't recovered in the crime scene? Or in a truck? Not a single baseball bat. Not a single one. But the state told you that they had a shard of, the state said it themselves, what could have come off of a baseball bat with blood on it. So the evidence will contradict itself It can't be the stabbing and it can't be the baseball bat.
Yeah, those jailhouse confessions are such shit most of the time. Again, it's just people lying on their
The
cellmates.
next item that the state
to get a
talked about
reduced
was
sentence.
the DNA in the van, and the state claims that there will be a witness that will get up here and tell you that that was blood in that van. And I'm not sure where that's coming from. Because Lisa Treffinger, who's an analyst at the state crime lab, was the individual in charge of processing the van and that particular dot. And it was so small, like freckle size. She's the individual responsible. And you'll hear from her and other state crime lab analysts that they processed that van extremely thoroughly. You'll see pictures of the van too. Not a van that's been cleaned. There's dirt everywhere, dust on the dashboard, no indication that it's been cleaned, no blood in the front driver's seat. In fact, no blood anywhere. They saw red dots, tested it for blood. They did a test that's specific to determine if a item that purports to look like blood is blood, negative. They did luminol testing. I don't know if any of you are aware of that, but what they do is they spray this substance and it will basically light up if there's the presence of blood. Didn't light up. They said that there was this one flicker of light, so they tested that area, negative for blood. This dot that the state claims someone's going to tell you was blood, in an email from Lisa Treffinger, the analyst that will testify, you'll hear her tell you that the state asked her, an email from the state, I just wanted to confirm that the sample that was sourced to Rosalio from the van was blood, right? This was analyst Treffinger's response, and she'll testify to this. We could not confirm it was blood. Her own words, not mine. DNA in his van, though. How do you explain that? The state claims that the explanation of how Mr. Gutierrez's blood got in the van was because Mr. Anderson must have killed him. But the evidence will tell you that there's a far more logical explanation for how that occurred. The state talked to you about the evidence that might come in about an incident that happened on April 24th, 2020, where Mr. Anderson had gone into Mr. Gutierrez's vehicle, had taken something out. This was talked about between Ms. Beecham and Mr. Gutierrez at length. Ms. Beecham told Mr. Gutierrez on April 25th about what had happened, how Mr. Anderson had gone in his car. And they talked about how maybe something should be done about that. There was conversations between them about how maybe Mr. Anderson should get a taste of his own medicine. Later that night at 11:10 p.m. on April 25th, 2020, Ms. Beecham received a text from Mr. Gutierrez that said, "What's his fucking address?" Sadie responded, "Well, I guess if he has your info, you should have his."
Oh, women.
And then Mr. Gutierrez sends her a text with Mr. Anderson's address. This is on the 25th. And then on the 26th, he sends her a text that says, "For the record, only if you say it's okay." He also sent, and then Ms. Beecham sends him a text, "He's gonna find out." This all happens on the 26th of April. Mr. Gutierrez is apprised of the fact that Mr. Anderson went into his vehicle. Sadie and Mr. Gutierrez talk about how something should be done similar to Mr. Anderson. And then On April 26th, 2020, Mr. Gutierrez's Cellbrite location data puts him at 6813 Highland Road, Mequon, Wisconsin. He's there. Mr. Gutierrez, after talking about how something similar should be done to Mr. Anderson, that something similar being going into a vehicle, is at Mr. Anderson's house. His location puts him there. And then right after he's there, he has a video FaceTime with Miss Beecham for 2.5 hours. And that conversation occurs at 3:11 a.m. in the morning. In addition to the fact that there's more reasonable explanations, as you'll see through the evidence, that is ignored by the prosecution, the fact that the timeline illustrates Mr. Anderson could not have done this, the fact that no one puts him there on May 17th, 2020, the fact that there is no blood in the van, there's no body, there are no remains, there's no murder weapon. They still are going with the fact that Mr. Anderson committed this crime. That's because, remember, that's who they chose as their main character. They ignored, and by they I mean law enforcement, ignored legitimate leads and follow-ups, suspicious people. And they ignored that because on May 19th, 2020, when law enforcement met with Sadie outside of Mr. Gutierrez's apartment, she said, my ex had something to do with it. And they said, great, let's run with it. We're going to try to build a case around him, even if we don't have a body. We have no explanation of what happened to him. We have no explanation of where Mr. Anderson would have put a body. We're going to run with him. So what did they ignore? They ignored Miss Beecham. Miss Beecham, as the state noted, went to Mr. Gutierrez's residence at around 11 a.m. on Monday, May 19th, 2020. She had only been dating this guy for a couple months. This guy was dating other people. They only saw each other every other weekend, some weekends. It wasn't a hot and heavy relationship like the state wants it to purport. The evidence isn't going to show that. So she's only been dating this guy for a couple months, a guy she met off of Facebook dating, and decides, you know what, I haven't heard from him. I'm going to go to his house in the middle of the day when he would be working to see what's up. Sure, there could be innocent explanations to that, but you'll also
I like this lawyer a lot.
hear evidence that Miss Beecham had constantly been texting with her best friend, Rebecca Jekyll, about how she thinks Zach's tracking her, but can't prove anything. She says that. She says that to Rebecca Jekyll, and she's complaining about it. And this is all on 5/14/2020. She's complaining about it. Text messages between her and her best friend, Rebecca Jekyll. And on May 14th, 2020, Rebecca Jekyll randomly texts Sadie Beecham and says, in this discussion string where they're discussing how she, is so irritated with Mr. Anderson, Miss Jekyll sends a random out-of-place text that says, phone call has been placed. All I was told is it will begin and you will not know when, where, or how. Call me in 1 week. And what's 1 week later? When she's at Mr. Gutierrez's apartment. So if we could have the
There we go.
outside the presence of the jury.
Go ahead, Ms. Gravely.
Yeah, what?
What did you say?
I do want to do it outside the presence of the jury. I apologize. This thread is something that we've litigated prior.
Dude, hey, shut up. Wait for the jury to leave.
Quiet, please.
There you go. There's some Schroeder coming through.
Step just into the library. If somebody needs to go upstairs, you're welcome to do so, but come right back down. but go into the library, and I don't think this will take long, and make yourselves comfortable there, please.
That's the
Don't talk
Bruce
about
Schroeder
Chris,
we
please.
all love. That's the Bruce Schroeder. Just as I said, shut up. Stop talking until the jury leaves. J. Cal, not saying you should be locked up for circumstantial evidence, but my gut instinct is that there's definitely a killer in that courtroom. I got to say, we're not even done with the prosecution's with the defense's opening statement, and she is hitting some home runs with this. The prosecution, I think, has a lot of space to make up. They got a lot of room to cover to prove the guilt. And Chaos Coordinator came here during my work for mental support from Jeff and chat. Hey, Chaos, mental support.
Gravely?
Feel much better now. Hope everything.
I hadn't pressed the button. That's why.
My objection is that the defense line of argument that's just been stated regarding Sadie Beecham is a violation of State v. Denny. To be able to name a party and indicate that there are factual circumstances that are consistent with them being guilty of procuring this homicide in the alternative is exactly what Denny was designed to prevent. The court is aware that Denny asks that the defense file a written motion giving all parties notice so that the parties do not, in mid-trial, have alternative actual named parties be described, as well as factual circumstances which are designed to cause the jury to suspect that person is an alternative individual. This is exactly what Denny was designed to prevent. And now the name Sadie Beecham has been associated with this jury with being involved in planning a homicide of this individual. And that's in direct violation.
Holy crap.
There is no doubt that the defense is on notice as to what Denny is or its expectations. We litigated a Denny motion just last week where they laid out a direct foundation. These are, again, the quoting to the jury are text messages. These are not new pieces of information. And frankly, as I indicated in the prior Denny motion, the court has an obligation as a steward of this information to be sure that all parties are dealt with fairly here. We are required to be able to be provided notice if individuals are out there in that situation and be able to defend those individuals, and the court is required to rule on this beforehand. So I believe this to be an improper argument. I don't think it can be cured at this point, and so I ask the court to consider what our remedies are, but I believe that this is a clear Denny violation and that this is a mistrial.
Oh, come on.
If I may be heard, Judge. Thank you. In my opening statement before I started going into this sequence, I talked about how law enforcement did not follow up or look into anything as far as possible other suspects or leads. I'm not offering this. And first of all, I'm just talking about the evidence that's going to come in, right? At this point, this is what the opening statement's for. This is a message string between Miss Beecham and another witness. This will come in. And it's not to offer it, Judge. It's not to offer it to say it was her. It's to offer it to show that law enforcement did not investigate her, did not investigate anyone else. That's not a Denny motion. I'm not pointing the finger. I'm not saying Miss Beecham did it. I'm saying they could have followed up on this. They should have followed up on this, and they didn't. It's very different.
First of all, you're telling me it's not coming in. And if it's not coming in, then you're not supposed to talk about it.
No, I said it is coming in, that this will come in through witnesses.
Say it wasn't going to come in.
No, sorry.
I heard you wrong.
Okay.
Did you want to respond, Mr. Waverly?
Yeah, you can talk about whatever purpose you want. The argument made to the jury is other people should have been looked at. I mean,
yes.
You couldn't be more clear in your argument. The argument was other people did this crime. My client did not. Other people did.
That's not what she said.
Here's example one. And she's
That's
now
not what
laid
she said at all.
specific electronic evidence that she wants the jury to be presented. So not only is she making an accusation, the substance of this accusation is that Sadie Beecham and a friend of hers have conspired to find a third party who will kill this person. That's the allegation that's been just made.
No, it isn't.
She's indicating that's what the text would lead a reasonable person to believe. There's been no notice of that specific allegation. The jury has now heard it. It's been shared with the jury. There's a whole body of case law in Wisconsin that does not allow a private citizen to be accused. And for a person to say, well, that's not for the purpose of accusing another human being of murder, that's what she's done. That's the argument that's been made. It doesn't matter if that is not if that's not the sole purpose you have. Your objective here is to tell the jury, hey, there's reasonable doubt. Sadie Beecham did this. Look at this electronic message. That's why you argue that. There's no other reasonable argument as to why this has been shared with the jury. And why weren't we given notice of this? Why wasn't, when a Denny motion was filed with all the details, and I complimented the defense just a week ago when they provided their factual circumstances so the court could litigate that with the state, because I believe that's the entire proper procedure. I'm on record as having complimented them for supplementing and providing a factual basis for the court to make a fair ruling. And we are in complete absence of that in this situation. This can't be remedied. Sadie Beecham has been accused of murder when Denny exists as litigation in this.
She didn't accuse. She just said the police didn't look at other people.
If I may respond.
Go ahead.
Thank you, Judge. I have not accused anyone of anything.
Exactly.
I think it's been very clear that the defense is saying that none of this evidence exists, and law enforcement, instead of doing their jobs to investigate, just went with a single individual, that they had tunnel vision. An extremely proper defense, and this does not fall under Denny, is to say what the law enforcement didn't do. I'm not here to purport that this is what happened, nor have I said that. During trial, it'll be, this message was sent. Hey, detective, were you aware of this? Did you look into it? Do you think it's a little bizarre? Yeah. And leave it at that. Nowhere have I just said right now that I intend on pinning this all on Miss Beecham, nor have I think that has been the theme of my opening statement.
But if you don't have greater information than that, and why is it relevant? I mean, what difference would it make whether the police followed through on it or not, unless there's reason to believe that that was the person who was responsible for the disappearance of the decedent? It's irrelevant. And I mean, I'm hoping they didn't investigate me too, or Mr. Gravely, or Ms.
Well, look,
Rivera.
she's a defense lawyer. She's either my guy did it or my guy didn't do it. If my guy didn't do it, someone else did it, so they should have looked for somebody else.
That Ms. Beecham was involved, then I think Mr. Gravely is quite right. This is just a camouflaged Denny effort.
The defense would respectfully disagree with that, Your Honor. By sustaining the state's objection, the court would ultimately be holding that the defense cannot go into how law enforcement didn't do their job, which in a case where there's no body, no evidence of human remains.
Why didn't you file a motion?
It's not a Denny motion. I'm not offering this to point the finger at someone to say this person did the crime.
I have an alternative actor theory.
It's not an alternative actor theory. And if I could maybe give a preview to what was going to come next, is the 20 other things that law enforcement didn't follow up on. It's more targeted, if I may finish. It's more targeted to what law enforcement did or did not do, opposed to what some third party did or did not do. That is what this is going towards. And the defense would maintain that that is extremely relevant. It does not fall under the curtails of Denny, and that we are permitted to go into that in opening argument and during the pendency of this trial.
Okay, I want to be heard on the precise thing that was said by the defense, because this is a disingenuous argument to say, my argument is just a police officer. Here's the text message. Isn't this weird? That's what she just told you. Here's what she represented to the jury. She said that she read the text message and said that this mysterious third party will take care of this, but you won't know the details and we'll know in a week, right? And then she said, she commented to the jury, and a week is when Sadie Beecham goes and discovers this bloody scene. So she ties it in. She says, guess what, jury? At the end of the week, it's Sadie Beecham who, in response to this message, has now made this discovery. This is implicating Sadie Beecham directly in a homicide. That's the only reason you make that argument. She didn't remark, and I didn't object when she first began to speak. What she told the jury was that this is bolstered by Sadie Beecham being the person who discovers this scene a week later, which is in accordance with the detail with the text. This should not be investigated by the state on the fly. This is just not Denny does not allow a scenario where a fellow human being can be accused of a homicide and the state is expected to figure out on the fly what this information leads to. The jury has every reasonable expectation right now that Sadie Beecham could be the killer based on what's been said. That should never, ever be said in a courtroom until Denny is litigated, ever. I mean, this is a line that it's not even a close line that's being crossed here. And we
come on, stop
for this jury.
What I was going to say before the objection came was that even just, okay, so it's still, again, not being offered to point the finger at her. And I'm not
frankly, your Denny motion that I denied with respect to Mr. Campbell, I might have granted the one on this one because there is not more body to it. So I think Mr. Gravely correctly is concerned that this is just, as I said, a camouflaged Denny motion or effort.
I disagree. The defense disagrees. This is law enforcement. So we can't go into how law enforcement investigated this crime then. Would ultimately be the court's holding, because there's
that's not the court's holding.
So why didn't you investigate the person who just happened to find all of this? So is that pointing the finger?
That's not the issue before me. This isn't midway through the trial that you didn't ask some probing questions of the detective if he testifies. And ask, well, did you look at this? Did you look at that? To try to show a sloppy investigation, if you think it was. This is in your opening statement and planting a seed and it's all right to plant seeds. That's why we have opening statements. But this particular one has a special body of law handed down to us from the Supreme Court of the United States. And as I say, you correctly brought the Denny motion on Mr. Campbell's issue, but
he's about to tell us.
I think this is, well, it's in the same category.
If I can further be heard.
Yeah.
So what is the difference then between saying law enforcement, because I do anticipate talking to Carrera and other detectives about these messages, about whether they looked into any other possible individuals, which is not a Denny motion. And so what's the difference between me saying to a jury in an opening statement, which is what I believe the evidence that's going to come in is going to come in, that this message is going to come in, and law enforcement did not follow up on that.
I'm not going to pre-screen what you might or might not ask.
But I'm saying
you're capable of making your own decision about whether you want to ask the question and what the risk would be. But this is a concrete issue that is before me now, and I think is correctly analyzed by the state. And what I'm struggling with is what to do about it.
I hope not.
Well, Judge, frankly, a Denny requires notice. So this jury is tainted. We need the court to provide us an opportunity for, if this is an argument they wish to make with an individual identified, they need to notice us, provide us what the factual basis is they're going to allege, and allow us to counter that. This is what happened with the Campbell situation, right? We had the police look at their information, do an investigation that would allow the court to be provided both sides of what that information would entail. And then the court is able to make an educated gatekeeper determination. That wasn't done here. Counsel would be prohibited from arguing an opening or closing without Denny guidance, without the court gatekeeping under Denny any of this information. So under whatever shield they want to use, whatever they want to label it, it still can't be argued in opening or closing as something that is alleged in this case unless the court gives them permission. This is a mistrial. You cannot take away a suspect from a jury. You can't do it.
No.
And they should provide the proper notice, as Denny requires, as they did on the prior attempt, and we should have a chance to litigate that before this court. And it shouldn't be a day's notice. It should be sufficient notice for the state to do a real investigation.
Naturally, the defense is maintaining that this isn't a Denny issue. As far as notice, if this is concerned that this text message is coming out of nowhere, these are records that were provided by the state. These are records that the detectives in this matter have went through months ago. They've seen this text message, and if they haven't, that's on them. It's not my fault to make sure they've looked at every piece of paper in the discovery that they provided to me. I found it. I intend to use it to show that law enforcement honed in on my client and didn't investigate anything else. That's not a Denny issue. So as far as notice, the states had this information. I'm not using it to point the finger at Sadie. I'm using it to point the finger at the fact that law enforcement did not do an effective job investigating and instead painted my client in a certain way. And as the court's aware, this is a bodiless homicide. There's no human remains. There's nothing. And the investigation of law enforcement should be the focus of a defense here.
I'm not sure that it makes any difference whether there's a body or not in terms of this particular issue. But now, before we break, so that I can look at the authorities on this again.
Oh, Jesus.
Fuck me. Just so.
Do you know what's going on right now, Ozzy?
Ordinarily, I have an individual colloquy with the defendant when there's a motion for mistrial.
Gathering that there were motions
about,
and he's being very
mistrial.
thorough. No.
And,
Motion for a mistrial.
Actually, the first case here was dismissed without finding on jeopardy. I didn't have. It was ended up as a motion to dismiss without prejudice. And I'm not obliged to go through a waiver colloquy with you, but you need to understand that if you're wrong about this, and I agree with you, and am wrong about it, you're done.
Yeah, I'm aware that the appellate court makes its own decision on these matters. I'm aware of that. I'm aware that the body of law indicates that if the court makes discretionary decisions, and if the Court of Appeals agrees with the court's exercise of discretion that the defense has engaged in a form of misconduct in this case, that jeopardy does not attach. So, I understand that the Court of Appeals could disagree with the court's exercise of discretion, but I believe that is the litigation that would take place.
Well, you refer to it as an act of misconduct by the defense. It could be an act of mistake by the defense.
Absolutely. Right. Yeah. When I say misconduct, I mean it in the broadest sense. Yeah.
Okay.
But clearly it was a deliberate argument, and it was a deliberate decision to not file a Denny motion. So this is not an accident. It may be a disagreement about the law, but this is not accidental conduct.
Well, I don't want to get into that other than to say I made a comment that I thought that her argument on this issue would have probably been stronger than I didn't say probably. I said was stronger than the one with the other. I don't know. I'm stumbling.
Campbell.
Campbell.
Right.
But she could have also, in good faith, thought the other way. And she brought the one on Campbell, and I denied that. Maybe she felt that was the stronger. That's not deliberate. That's a deliberate choice for her to bring that particular motion, but it doesn't mean she thought that she was bringing the weaker of the two. That doesn't make any sense.
No, she has an obligation to bring a Denny as to each one.
I agree.
Yeah, it's not like an appellate.
But you're saying it was
Also, if I may, I'm
Please.
here and can make the record myself of why I did
You know
something.
what? She's a wonderful, experienced, fantastic reporter. And she's trained. If more than one person is talking at the same time, take the judge. And I don't doubt she could probably take heated discussions, 2 or 3 lawyers at one time. But I don't want to rely on that. You're all talking. And when I start talking, not because I'm so bright or so capable, but just because you're talking to the air. It won't get into the record, or you can't count on it being in the record. So I'm talking. So, and I've forgotten what I wanted to say.
Don't talk over each other.
Yeah, you know, I don't want to get into purposeful. Well, it was purposeful, but whether it was a willful matter is
Oh my God!
willful
don't-
in the
don't
sense of
declare a mistrial.
trying to avoid application of the rule. I'm not in that situation. I don't have to be.
Right.
But it needs to be understood, and you can say for the Court of Appeals, if there is an appeal out of this issue, your thoughts on the subject of whether her conduct was improper or careless or
Okay, it sounds like he's not going
or
to give a mistrial.
purposeful in a negative sense. So I'm not going to even touch that right now. I do want to look at the exact statement again, and I'll take another look at Denny and the prior Supreme Court decision, and I'll ask the jury to return at 1:30. And, well, actually, I asked them to
Don't do
return
that.
at
I already feel bad as it is.
1:45.
Don't do that.
And we'll talk about legal issues when we get back here at 1:30. Any question?
No.
No question. A request, though, if the court could review the statements that I had made prior to my statements about Sadie Beecham as well, because I think that provides the court context as to why those statements were made.
How far back do you want?
To the point that I talked about how law enforcement didn't look into things that should have been followed up on.
I don't think that was a great stretch of time.
No, it wasn't. It was probably like 2 minutes prior to that statement.
All right. Would you, that please? Do you have enough time? Thank you.
We're back at 1:30.
1:30.
Thank you.
Let's get the jury in. Oh. What is the question?
You want to? Can they just stay?
Jury is going to come in.
Oh, okay.
Yes,
Just for a moment.
you bring them in, then you dismiss them again. That's the right thing to do, stupid prosecutor.
What do you want to do? Okay.
I'm okay with you just
You always
communicating.
make it come out well.
Judge, I'm all right with you. The court just communicating with the jury that we're adjourned until 1:30. If the court wishes to do that, just by either note but if the court wishes to bring them down, that's fine too. I just am suggesting that's okay.
I don't like to talk to the jury unless it's on the record.
Okay.
So it's just going to take a minute.
Oh,
Oh, they're
thank
in this
you.
room? Okay.
I guess just put it down.
You didn't actually have to go to the back. Oh, okay.
Holy crap. Wow.
Yeah.
Well, dang. Natalie Wisco, why did you abandon us in our moment of need? No, there has not been a mistrial yet. My
All
gut
right, folks,
feeling is he's not going to.
I'm glad I told you that was going to take about 20 minutes. I
No, you
did
said it
tell you
won't take
20,
very long.
didn't I?
No, you said it won't take very long.
Did I say 5? Well, anyway, we're still working on a legal issue, and I think it's an appropriate time for a break. So I'm going to ask that you return at 1:45.
There's an hour and 15 minutes.
And that'll give you a break. And also, we do have some more legal issues to discuss, and we delayed the other one. So I'm going to spend at least 15 minutes with the lawyers.
We've summoned her.
With the lawyers. And
You literally did.
poor reporter she's been working since start, and now I wanted her to type a little part of the transcript. So it's going to be a little bit of time, but I'm hoping if you're here at 1:45, we'll get to you. 1:45. We'll get to you shortly after that. Please don't talk about the case. Read, watch, or listen to any count of the trial. Any question? Okay, thank you very much.
No,
Wow.
I heard my name, so
Yeah. Well, let's get these. There's a couple super chats to get out of the way real quick here. Then the curse of the Oz. Yeah, poor Aussie Overlaw'd. He was going to stream a trial of 2 weeks ago, and they brought up the court feed, and then they immediately brought it down because they settled like literally 5 seconds before the jury selection started. Lost that trial, and then he had this other piece of crap trial he's been watching. Unhung hero. This lady reminds me of a 16-year-old girl with attitude. The mannerisms and facial expressions are very off-putting. I love this defense lawyer myself. I think Schroeder's age is taking its toll. I love me a chunky mid-30 blonde attorney. Thank you very much for that. Flux, Hayden showed interest. Mistrial, laughing my ass off. And Stingy,
she's
when my
early
hand goes up,
30s.
your
She's
mouth
not
goes shut.
mid-30s. Sorry.
Is the blonde reporter's nickname Mistrial? Okay, my question, I don't know if how closely you've been paying attention to the people, but do you know who or what the function of the girl sitting directly behind the defendant is?
That's probably somebody who is like the paralegal.
That's what I assumed.
That's what I would be assuming is that's paralegal for them. That's not an attorney. Actually, I could look up on their website. See, I was
just curious.
I think that's one of their paralegals.
All right. Flux says, I've never seen a Denny objection in real life, nor have I. But okay. Wow. What just happened there? That's and this just Judge Schroeder drives me crazy because he's aggressive with both parties. And I have no idea what he's gonna rule.
Well,
it's freaking me out.
My thought is if he was so the thing about Judge Schroeder is the man hates wasting a jury. Absolutely hates it. He will try and keep if he is also though very much towards defendant constitutional rights, things like that. So he's way, I think in general, less likely to do a mistrial based upon defense conduct than he is on prosecutor conduct unless it's intentional and egregious. That's kind of my opinion of him is he does like to protect a defendant's constitutional rights. So he's more likely in general, I think, to, do a mistrial based upon prosecutor conduct than defense conduct. But, he goes with his gut. And I think that if he was going to deny it, he might have already, or rather going to grant the mistrial, that he would have already.
I took solace in the fact he was talking about the appeals at the end.
Yeah. And that's the thing is,
what is a Denny motion?
Okay.
Give us the basics of that.
Denny
first.
is the case in Wisconsin that governs third-party liability. So that was actually something at issue with Stephen Avery's case specifically that came up. And there's, if people have seen the Making Murder documentary series, is that they wanted to introduce evidence in that case that specific evidence saying not that just somebody else could have done it, but that somebody else specifically could have. They are named, and it's used as a defense for the defendant being like, you know, not just generally anybody could have done this, but we're going to specifically try and point our fingers at this person. That was something in Avery that came up. If you've watched the documentaries about that, about, like I said, with the some of the other people who are adults that were living on the property, you know, that they wanted to be able to put in specific evidence in that case saying, you know, this person specifically also had time, opportunity, motive, stuff like that. So it's the evidence of third-party liability. In general, there's a big difference, as Nicole was arguing, between anybody could have done it and somebody specifically could have done it. And that's kind of the difference here that they've been arguing about, is that state's trying to say, look, she's specifically saying that, you know, pointing the finger at this person. And that's where they're coming in. If that is how it was done, you know, they would arguably be correct. I think that's also another reason he's looking back at the transcript to see the context in which she made those statements.
And I didn't feel like it was.
I didn't feel like it was either. I felt like it was, you know, like I'd said before we went in, you know, you're going to point out things of what they didn't do. My thought is she probably has a bunch of those people in her opening that she's like, you know what, they could have investigated this person and they didn't. They could have investigated this person and they didn't. They could have investigated this person and they didn't. It's not.
She's a defense lawyer.
Yeah.
She's got two choices. My guy did it or my guy didn't do it. And she has to say my guy didn't do it. And if he didn't do it, somebody else did.
Yeah. And that's the thing about it is, you know, there's I mean, I think, but I'm a defense attorney. So, I mean, I think she should do it because that's what I would have done too.
Of course you would.
Well, perhaps in a different sort of stylistically, but you know, you're talking about her delivery, stuff like that. You know, she went to Columbia. She's from Washington, D.C. That's why she's got a little bit of her New York accent in there, is because that's where, I mean, she lived for a long time. She's a sassy lady. And, you know, I think everything she does is intentional. So she probably, you know, like I said beforehand, is some people like to push it right up to the line. But I mean, I'm sure she made a lot of consideration as whether or not that crossed over. So at least from her perspective, I mean, she had a well-structured argument. I think she thought about this beforehand. It gets down to the issue of interpretation of Denny.
See, and Hayden doesn't have any idea what she said, so we'll have to go back.
Running back through the feed so I can listen to it myself.
Yeah, we'll have to go and we can watch her opening again because we've got an hour and 15 minutes to kill over on you when we get out of here. But the thing was, I had two immediate thoughts when he made the objection and started his explanation of why he wanted a mistrial. One, she got the mistrial on him for him screwing up right after the opening statements in the last trial.
Yeah,
and this was a revenge thing. That was the first thing that went through my mind. This is him wanting revenge for her doing that. Gamesmanship. That's I did not like the way that felt. And the second thing I can't remember. The problem with the
other one though is like there was evidence that wasn't disclosed.
Yeah,
and that's a much different than you know sort of an element of strategy type of thing. And also, I mean, I'm personally, you know, the Kenosha. This is not the first time that the Kenosha County District Attorney's Office has been accused of not giving somebody evidence. And under Mike Crapely. So, I mean...
Now, he is the actual DA, correct?
Yes, he is the actual DA.
Is it unusual for the actual DA to try cases themselves?
No, I mean, they usually do, but he only picks cases that he picks cases for a reason.
Yeah.
There's a reason he didn't do Rittenhouse, because he didn't want to. I mean, in general, my experience with him is he takes cases that he thinks he can win regardless of whether that's rooted in reality. So, and that's his normal cadence delivery style in every case. Yeah. That's just kind of how he works. That's how.
And my second thought was she went in so hard, and this opening that she gave this time was 100 times better than the first round last year.
Yeah.
I mean, I
didn't watch the first round last year. Yeah. I mean, She did well. I mean, it's looking at the what did they not do and using it as a rebuttal. You're directly incorporating the things that they said and finding holes in them, as opposed to just generally, we're not just painting this broad picture of this is what I think it'll show. If you want to be an aggressive defense attorney, you attack things. And I really enjoyed the parts she was doing of that is, you know, let's look at this specific thing that they said and why it's bull.
And I don't think he was expecting that.
No. And I mean,
And
it's
I was like, holy crap, let's pull the ripcord on this one and try again next year.
I mean, I don't know if he even, I mean, I don't, this is no offense to Nicole at all, but I didn't think she was going to be doing opening. I thought it was going to be either John or Kirk, just because, you know, they've been around doing this so much longer and it is a pretty high profile case. You know, I don't know if he, but that also can be a secret weapon in different ways. Is, you know, if you think that one attorney is doing something, you prepare for their delivery in that aspect, and you can really mess up the flow by throwing somebody else in there.
Wow. So what do you, I guess you think he's going to?
I think he's going to deny it. I think he's going to do it. I think he's going to give a cautionary instruction. I don't think that he wants to do this again. And it will depend upon, you know, the language. I think that that's going to be the swaying thing in his favor. My general opinion is if he was going to deny it, he already would have denied it. Because he also doesn't like wasting, or rather, if he was going to grant a mistrial, he would have granted a mistrial because he also doesn't like wasting the jury's time. So I think that, you know, unless he goes back and sees the transcript saying, you know, she directly saying she did this or whoever that other person is, my tendency to think is that he's going to let it keep going.
Well, and that was my other thought is even if she did say that, I believe it would have just been a misstatement and not a direct, we're trying to get this in. Because she was just rolling along.
Now the state brought attention to it. That's the other thing that I'm talking about is it's a lot easier. Like if they, I mean, it is strategy. And, you know, some people fight every fight, but you have to, you're playing chess. You're not playing checkers. So, and I think that that's somebody that, you know, I don't have a ton of experience personally working on cases with Gravely, but I've seen him. And I think that he, you know, has a tendency to maybe not think about as much of the long game.
Wow. I mean, that, and they were, the arguments they were having with each other, they were going hard at each other. And I liked her for essentially, I mean, putting her life on the line by interrupting the judge and just telling you, just wait a minute. I'm not done here.
Well, and he's somebody though, like if you're in the middle of saying something and you're like, I'm not done, he's much more likely, he'll go for that. If it's because he does want to let you finish. If you just interrupt him, that's a different story entirely. But if it's kind of like, you know, oh, I paused.
Scares me after just how he savaged Binger repeatedly.
I mean, if it's you pausing to collect your thoughts, that's a different than stopping. And I think that he also likes to have a complete record. I mean, in general, yeah, he does have a big bark. He's a very like silly kind of person in lots of ways. He's a huge Milwaukee Brewers fan. You know, he's got a lot of weird idiosyncrasies, but I was summoned. I got to leave again.
All right.
I have a meeting, but I'll be back around.
All right. Thanks for that. That was great. Natalie Wisco, Rittenhouse attorney extraordinaire and super awesome lawyer in her own right. Hayden, welcome to A Possible Mistrial.
Good morning. Thank you for inviting me.
Wow.
Shit as it is.
So what I'm thinking would work best, and I mean, of course, once we send it over to you, I mean, that's incredibly entirely up to you. Just kind of brief you on what was going on up to this point, and then you may want to just go and redo her opening.
Yeah, that might be the most straightforward thing to do.
See the argument. Because we've got what, an hour before that starts. So he went on for like an hour and a half.
Oh, really?
It was like one of those 3 hour and a halves.
Oh, yeah. Okay, that's not what you want to do in opening statements either.
Yeah, but it wasn't horrible. But she was.
I mean, she went for what 58 minutes last time around, and he went for an hour and 30 odd. So it's probably par for the course for his sort of opening statements. But I mean, in terms of it, was it much different in your opinion?
There were some overlapping statements, but there was several details that were changed that I thought were interesting.
Oh, interesting.
And while I was doing this, I was thinking, unlike other trials that I've done, I think I need to take notes for this one.
Ooh, right.
I think this is something to take notes on. That's there's a lot going on here. I mean, he started out. I mean, I don't like his delivery. He's shouty. He's a shouty lawyer that he doesn't really use the microphone. He just prefers to shout.
Oh, great.
But that's,
So
I mean, that's
he
just
didn't learn his lessons from the last one, basically, is what you're saying. He's still not
Yeah.
talking to the mic.
Yeah, I mean, I mean, it's a personal idiosyncrasy of his, I guess. But he was kind of disjointed. It wasn't really a linear presentation. He said we're giving you a roadmap, but it was sort of like a roadmap that you're trying to fold back up, and it never folds up quite right.
It's like you're trying to go and see all the road trip attractions rather than taking the highway down.
Well, I mean, for example, he spent so much time talking about how he was a loving father. He took all these kids to all the baseball games and did all these other things, and how he was looking forward to going to this camp thing. I mean, it was maybe 10, 15 minutes of stuff like that. And I'm just thinking, why? What's the point of it? The only point I could possibly conceive of was he was saying he didn't just run away.
Yeah.
But there's blood all over hell in the house. So he would have run away to a hospital if he would have run away. But I mean, in no way does, he loved to play baseball with his kids prove someone's a murderer.
I do legitimately hate it when the prosecutors rely on the emotions of the jury as opposed to providing evidence and an actual motive or anything like that as part of their argument. I mean, look, if you want to include it, that's fine, but don't harp on about it for a significant period. I mean, it's what we've seen with the Murdoch trial is that they're harping on about how they reckon he's a POS or whatever.
Yeah.
And, but anyway.
Yeah. And Legal Vices, can you ask Hayden if he forgot his stream was waiting for him? Yeah, we know. So we're trying to find a natural breakpoint. How many people you got over there?
That's a good question. I should probably open it and have a look.
So while you're doing that, I'll tell people we got 451 people here right now, and just because it's the middle of the freaking night for both of us, it's 3:45 a.m. for me, and it's coming up on 6 a.m. for Aussie. What we're going to be doing for the next 2 weeks, or however long it might be, for like another hour and a half. But assuming this continues, what we're going to be doing is I'll take the morning session, and then whenever Aussie wakes up, he'll pop on in here. We get to the lunch break. I'll brief him on what's going on, and then we'll flip on over to his stream, and then I'll probably go to sleep and get a couple of hours before I have to go to work. So it's a tag team thing we got going here. So when we eventually,
full disclosure, today will be slightly different, only because my assistant managed to put a appointment in right at 9 a.m. So the last hour or so, if it continues through till 5 o'clock, there's not going to be a huge amount of commentary, mainly because I'm going to be in the car. I will keep the stream running so that everyone can watch to the end, and I will comment as I can.
Cool.
You got to do what you got to do. But I'll
gotta make some real money
happen in the future.
So what'll happen is when we wrap up here in 5 or 10 minutes, we should get automatically filtered over to Hayden's stream. But it's out of, I was like, boomer, I didn't get sent over there. It is totally out of our hands once we click that end broadcast button. Most people get sent over. If you don't, there's going to be a little box at the top of the chat that says, ooh, there's something exciting happening over at Aussie Overlaw'd. Click here to find out what. Click on that. You should get directed over there. If you still don't, then go to Aussie Overlaw'd. Just search for Aussie Overlaw'd and go to whatever video is coming up as live. We're going to be doing that very, very shortly here. Just kind of clear off some things. Pleb Life says, what are the chances that the defendant X killed her new boyfriend because her new beau wasn't exclusive? Well, that she may have killed her ex-boyfriend is actually the reason we might have a mistrial here, because that was being floated as a possible theory. Wow. It could be anybody, and that's what the prosecutor, I think, was attempting to say. They didn't check the ex, they didn't check the guy down the street, they didn't check the milkman, they didn't look at anybody. And Matt Rufus said, how did the DNA get in the van then? See, I don't want to spoil too much of this because Aussie's going to go back and watch the defense's opening again. And she kind of went down for all of the problems that I had with his opening. She kind of started to go through them, but this was an interesting thing on his opening statement. The prosecutor, remember they said that there was like this speck they tested and it was blood. He kind of backtracked on that a little bit and said this speck was so tiny that they couldn't run a field test on it because they thought they would destroy it. So they had to collect this tiny speck and they ran a test on it, and it came up as possibly being blood. He phrased it some way that sort of went from it was blood to it indicated it may be blood.
So did they get a positive DNA test off it or not?
Well, we'll let her tell you about that in her opening statement. It's kind of interesting. But yeah, he was saying but they determined it may have been blood by process of elimination because they couldn't do the field test. He's like, it's not semen, it's not, it's like, dude, it's like well, as I said, that if you're confusing blood with semen, you've got a lifestyle I don't want to know anything about. But so he eliminated all these possible things and said, oh, so therefore it must have been blood. We believed it must have been blood. We ran the test, and then then she addresses it. But that was one of the big things, and then she talks a lot about other stuff. So I think this is a great time. Are you up and running and ready to go? You need a minute. All right, while you're doing that, I'll do my closing grift here on my stream. We're going to go over to Aussie Overlaw'd now. But first, before that, what we got coming up, hopefully for the rest of this week and next week, we'll be doing this trial, hopefully. And Thursday, before this trial, we're going to be doing O.J. Simpson retrospective that we do every Thursday. Where's Legal Vices located? Legal Vices is located in Korea. Like, three guesses where Aussie Overlaw'd is at, and your first two don't count. Yes, I am located in Korea, just 2 hours behind where he is, and it'll soon be next week. It'll be 1 hour behind. So Thursday is O.J. Simpson. That'll start at 8 a.m. Eastern Time, U.S., where we're going to go back and watch some of the O.J. trial, some of the great cross-examination that happened there. Friday night. We'll do this on Friday morning. Friday night, U.S. time, will be my monthly Fuck It Friday stream where we just say fuck it and we have a great lineup of guests, and I just grift for $100 shots, and we get me liquored up. I get all of my money grubbing done in one stream for the month. And then we go from there. We have a great panel lined up. We'll give you the great panel, and then we will wrap it up. If you're ready to go, you ready to go, Hayden?
Yep, just doing the countdown now.
All right. Hope it's a long countdown because it'll take me about a minute here.
I should put the show starting shortly back on.
or you can head right over there and we'll dump everybody there in just a second if you want to do that.
That works too. Okay.
All right. Do that and we'll have everybody there in about a minute. I'm bringing up, this is our guest panel so far. Our confirmed guests for the Friday drunken, grifty, boozapalooza, griftathon is Danny on direct, Drexel, friend of Nick Ricada, in case you don't know who Drex is, Runkle of the Bailey, Meme Copium from Japan, Nicholas Starov. He's a Viking lawyer. That's a union rep lawyer. He is going to be joining me because he wants to have a Viking drink off where he's going to match me shot for shot, he thinks. Our very own Maud Flux, she'll be there. Steph, the alter nerd, Chandler Remington, who does the OJ trial with me. Law and Lumber Rob will be there. Ari Jacob is going to be there. Our very own Aussie Overlaw'd is going to be there. And we also have confirmations from potentially Criminal Sean, Law of Self-Defense, No Tie Friday Night Branca, and Camelot 331. And then there's still others that might be joining. There's some other invitations out. You don't want to miss that. So right now, let's pop on over to Aussie Overlaw'd. Thank you all for being here. Join me same time tomorrow for day 2, I hope, assuming there's no mistrial. So let's go on over there. Thank you, mods. Thank you for everybody that's here. Thank you for all of you that subbed. Please make sure you're subscribed to my channel. I would deeply, deeply appreciate it. We are currently exactly... I'm going for the 35,000. I hope to get to 35,000 by Friday. And right now we are at 34,894. I need 106 more subscribers to get to 35,000. Thank you. Thank you for the super chats. Thank you for the chat. Everybody's great. Let's all head on over to Aussie Overlaw'd. We'll see you on my channel tomorrow. Larax out. Bye.